Good morning, everyone. Welcome to Art Law Day 2024. We are pleased to welcome all of you, those in person and our many virtual attendees. I'd like to thank the Art Law Day Committee, which is co-chaired by Stephen Schindler and Diana Rebecki, and all of the members of the committee. Each year, this group of dynamic individuals develops a thoughtful, topical, and exciting program that addresses the topics that are pertinent to attorneys, appraisers, and our affiliates within the art world. Founded in 1949, we are actually celebrating our 75th anniversary here at the Appraisers Association. Thank you. In that time, this association has become the premier association of personal property appraisers focusing on the fine and decorative arts and collectibles. With a membership of over 850 independent appraisers, affiliated professionals in 100 different areas of specialization, the Appraisers Association's roster of well-established professionals has the widest range of experience and expertise in their related fields, respective fields, excuse me. And as you all know, the value of working with credentialed appraisers and all of our members are required, as all of our clients are required to be certified in their areas and maintain the highest professional standards known as USPAP. Now, in recognition of our 75th anniversary, this year I am pleased to share with you a very short video that has been created in honor of this event.
And what do you see has changed since the old days, let's say, until now?
A lot. The old days, appraisals were not as defined as they are today. We sort of did a lot of appraisals by the seat of our pants.
The camaraderie is absolutely essential to establish the fair market value of a collection.
But families still need to know, what is this and what is it worth?
My name is Ellen Epstein. I'm a member of the Appraisers Association.
I'm Helene Fendelman. I've been a member of the Appraisers Association of America since 1978.
The Appraisers Association was started because there's a group of people that really needed to have other professionals to sort of bounce things off of. Art is considered an asset class, and because of that, valuations are necessary and relied on.
You know, I think what's made the Appraisers Association of America stand out is the fact that we try to provide the support, the services, and help to maintain the standards of people that aspire to be at the top of their profession.
Wow. This is catnip in the trade.
Fantastic, fantastic thing. Now, the value I gave you is an auction estimate value. An insurance figure on this would be somewhere between $150,000 and $250,000, probably toward the high end. I would say around $250,000.
Wow.
For insurance purposes.
The Appraisers Association's community gave me the opportunity to meet other members who approached me afterwards to assist them with appraisals in Europe for their clients.
The level of professionalism and knowledge of the appraisers gives a high quality value.
I was fortunate enough to go to China with the Appraisers Association of America to teach Chinese nationals about appraisals in the United States. And the Appraisers Association of America is the only group that was capable of doing such a thing. It put together a world-class program for Chinese nationals to learn about appraisals.
The Appraisers Association does have two components, the membership component and the services component, like continuing education, our appraisal studies program, our USPAP trainings.
Their reports are always thorough. I choose to work with them because I know that the reports that I'm going to get are going to stand up to the scrutiny of IRS and other needs.
The members of the association are super intelligent very professional, highly ethical. As someone in the insurance community, it is important to rely upon the documents that they produce and their expertise in the event of an insurance claim.
CASP is a summer intensive program that I would define as a boot camp. It was 4 weeks. I knew that it was rigorous. At the end of it, a community of folk who would also be a source of guidance, particularly as now I'm getting started.
My name is Young-hee Kim. My decision to enroll the CASP program was I have colleagues and friends, and having people who've gone through the program and their recommendation gave me a comfort of the quality and rigor of the program.
The CASP program has been invaluable for me because, in fact, I met my business partner there, and I am working with her and doing great projects.
The art insurance industry could not function without organizations like the Appraisers Association. On a very basic level, if we can't obtain reliable values for works of art, we simply can't insure them.
More and more affiliates are coming to us for art appraisals because the global art market just exploding, and they know that through our members they're going to get a knowledgeable, trusted appraisal report.
We look forward to many decades of collaborating together.
Congratulations to Appraisers Association of America for 75th successful years.
Congratulations on 75 years.
Well, congratulations for 75 years.
Felicito por estos 75 años y espero por muchos otros años por venir.
I'm looking so forward to being around for the next 25 years so we can celebrate the 100th.
Thank you. It's a real pleasure to be here for this milestone, and I'm very happy for this Art Law Day, and which would not be possible with all the work that went in, and of course without our partners that have been so gracious in hosting us today. So I would like to please welcome Barbara Callison up to the stage here, to the podium, and please thank her and give her a round of applause for thanking hosting us.
Thank you. And I want to point out Linda Selvin, this is our 5th year here at Cardozo. I am Barbara Colson. I'm the director of the FAME program, Fashion, Arts, Media, Entertainment, which including sports here at Cardozo Law School. I am a professor of practice here as well, and I spent 35 years as a lawyer in the fashion business. FAME provides training and development opportunities related to the representation of businesses driven by the creative process, from Fortune 500 companies to startups. We offer coursework, externships, clinics, symposia, and programs like today featuring industry leaders and practitioners. And we are so delighted to have had 5 years with Art Law Day. We're just absolutely thrilled. FAME hosts weekly programs and panels in all the areas, all the creative areas that I've mentioned. The FAME and Cardozo community is well represented in the art world. Samantha Anderson, who's here today, William Pearlstein, who's on our board, the FAME Advisory Board, Michael McCulloch, who teaches art law here, Abby Green, formerly at Christie's and now with her own firm, Diana Poussin, one of my students who's now at Gagosian, Carol Limburger, one of my former students at Sotheby's, and the list goes on and on and on. I encourage any of you here to be in touch with us through me, through Samantha Anderson, in terms of taking on interns, unpaid interns who get a credit, or hiring anybody for a summer job. Again, our students get credit, so it's not like an expensive endeavor. And thank you again for letting us host you here, and enjoy your day.
To invite the panel up, family law. Before we get there, I just want to I'm Linda Selvin, welcome. I'm so glad to see you all here today. We're off to a good start. For those attorneys that are attending virtually who wish to receive CLE credits, please be sure to record the verification codes. They'll be put up on the screen, and also the moderator will say them aloud. For those that are in the room and would like CLE credits, just remember to sign in and out after each panel. And lastly, I'm just going to briefly introduce the moderator. You have the full bios of all of our speakers in your program. So we're just going to mic everybody up. Let's get some AV out here. Are you guys okay?
You might self-mic. How's that? We sound okay? Okay. Does that work?
Everybody
All
here?
right.
Perfect. Excellent.
Let's do this.
Crowd here. Great. Okay, so our first panel is family law, and it's going to be moderated by Amanda Rotterman, partner in art and cultural property practice group at Loeb & Loeb. She has more than a decade of experience in art law, providing counsel on complex domestic and international transactions within the global art market. Amanda, I'm going to turn the panel over to you.
Good morning, everyone. I'm so excited to be here, and I'm so excited to share this panel with you. We just heard a lot about economic data and market in the industry, and now we're going to talk about the elephant in the room, and that's the emotional component of the industry. So many of us work with our collectors who are deeply passionate about their collections, and they take such a personal touch to this, and we know that emotion is throughout this industry, and I think that that is what this panel will touch upon. And we're so excited to give you a cross-selection and view across the United States with a panelist from California, a panelist from New York, and a panelist from Florida. So I'm going to introduce them now and get started. So first up, we have Alyssa Rower, who is the founding partner of Rower LLC here in New York City. She has been exclusively practicing matrimony and family law since 2008, and her priorities are providing unsurpassed service and guiding her clients through difficult transitional times. Next, we have Samantha Klein, a partner at Withers Bergman LLP in California. Samantha has over 20 years of experience counseling high net worth individuals through their complex matrimonial issues. And last, we have Daniel Lipschitz, who's a partner at Aronson, Majewski & Sloan. Daniel handles complex and contentious domestic and international disputes in Florida and New York, and he's a highly experienced litigator and very regarded for his accounting acumen. So let's kick it off. Daniel, I'm going to start with you. For the audience, can you tell us what is the difference between marital and separate property, and how does this distinction apply with respect to art?
So thank you for that warm introduction. Nice to see everyone today. Thank you for having us. So obviously every state is different. You have to, depending on where you are located, is going to govern essentially what laws apply. But essentially across the entire United States, there's two classifications of property when you're thinking about it in the context of a marriage and then ultimately divorce. Marital and separate or non-marital property. Separate property, essentially anything you come into the marriage with, anything that you receive as a gift or an inheritance, or things that you define in a premarital agreement or perhaps some type of agreement during the marriage. Everything else is essentially marital property. Anything that you earn and save during a marriage, anything that you acquire during a marriage is considered marital property that would be subject to distribution if you ever got, unfortunately, divorced. Non-marital separate property is not. How does that factor into art? Interesting, because art is one of those things that usually has a lineage, either from when you receive it, when you buy it, and so the way that art is usually classified is when you obtain it. And so when you enter into a marriage, if you have premarital property, such as art, then that is easily classified. If you acquire it during a marriage, it's important to keep records and make sure that if you ever were to get divorced, that you have the ability to classify it.
So I think what we're saying is there's this period of what's before the marriage, during the marriage, and understanding the delineations between the two. So Samantha, looking to you, how does that classification of property vary in California, for the most part, compared to other states that we're discussing today?
I mean, California and Florida, good morning, everyone, by the way. California and Florida are actually very similar. Instead of marital property, we use the term community property, and then there's separate property. And separate property is a gift or inheritance or something you had before marriage, or sometimes something very similar that you were confirmed in some sort of marital agreement, whether a premarital agreement or an agreement during marriage called a postmarital agreement. There are obviously some exceptions to what community property is, but a good example of a separate property asset is you're gifted during the marriage a piece of art. Maybe it's from your parents, maybe it's from whomever, right? And it increases in value during the marriage. Is that increase in value during the marriage community property, or is it separate property? And the answer is it's separate property because the piece of art was separate property in the first place. So you're able to protect that asset as well as the appreciation in that asset, which is really important. What comes up oftentimes with international collectors is that they live in they live in the UK, they live in Singapore, they live all over the world, and then they come to reside in California. Well, what happens then? Was artwork still divided that same way? Or is it, follow the laws in the jurisdiction where the art was purchased, right? And the answer is that if both spouses are living in California, we're going to divide it under California community property laws. It can be different if one spouse is living in California than another, and one is not. But for the most part, you're able to protect those collections regardless of where the art is purchased.
And just to build on that from what Samantha and Daniel noted, so what Daniel first said is that every state's law is different. So you have 3 out of 50 states here. And what's really important for collectors to know is what Samantha said. It's where you're living at the time of a divorce that dictates the law that's going to apply to your divorce. So Daniel is correct that the vast majority of states have this separate property regime and a marital property regime. But there are a handful of New England states, I don't know why New England, but Massachusetts, Connecticut, Vermont, amongst others, that are all property states, which means that everything in your name, even if you had it prior to a marriage, even if you had it, received it via inheritance, if it's in your name, it is going to be in the marital pot. So one thing to note, especially with couples who are moving all over the place, is that title might not be dispositive. When you acquired it, the source of how you acquired it might not be dispositive if you get divorced in Connecticut, for example. Even in New York, where we do have separate and marital property distinctions, it can be incredibly difficult to determine, especially with art, whether or not it's marital or separate property. So in New York, the presumption is that property is marital property. And as Daniel said, if you bring it to the marriage, it's separate property, or if you receive it during the marriage from a third party, it would be considered separate property. But the burden is on the person who is asserting that it's separate property to prove that it's separate property. So how do you do that? And one noteworthy item is that even if, let's say, I inherit money during a marriage, and then I put it into a joint investment account, I'm transmuting it and making it marital property. So while it seems simple on its face, this distinction between separate and marital property, in actual application, and why divorce lawyers are hot commodities often in a divorce, and why we have a lot to argue about, is that in actual application, it is incredibly difficult. People don't often save records of this was the source of this acquisition. Here's the money I used. So why is art more difficult? Well, title is not often apparent. So even though title might not be dispositive in as much as you cannot make something that is marital separate by moving it into an account in your sole name. To show that it's separate, you need to show I purchased it either before the marriage or via a gift or a distribution from a third party, and I kept it in my sole name and I didn't commingle it with marital property. So, sometimes with art as well, unlike a house that has a deed, a bank account that shows the date it was open, there can be issues of fact as to when it was acquired. I really liked what Magnus said about the NFTs, where we have a very distinct record of when it was traded or purchased, the title, because I'm not an art expert or divorce lawyers, but my understanding is a lot of that can be quite murky, which makes that separate marital property quite difficult in some cases.
Absolutely, and I think we all see that, and an element of what we're going to talk about as we get into this panel is the trusts and the different title documents and the invoice and the bill of sale and the insurance documents, and how this whole package of everything that's circulating oftentimes in our business doesn't match. And so that passport that we have with the art is murky, and that's why these three have a lot of facts to dispute when they're...
Yeah, and sort of also adding to something Alyssa said, which is interesting about art. When you classify non-marital or separate property and marital property, is that it is almost always an asset that appreciates purely by market forces. So when you talk about, as Alyssa was saying, you want to essentially trace when you receive the property so that you can prove whether it came in during the marriage or prior to the marriage. There's an aspect of trying to also sometimes try and argue with respect to assets in divorce that there were some type of marital efforts that increased the value of an asset. And with art, it's never that way. So my mentor, David Aronson, would sit down in a consultation and he would try and explain it, and he would use art as a perfect example. He would say, what assets do you have now? Where did you get them? How did they appreciate? Take art, for example. You put it on the wall, you had it on the day of your marriage, and what did you do to appreciate the value of the art? Essentially nothing. It sits on the wall, and perhaps the artist passed away, and it went from being worth $10,000 to being worth $1 million, versus a business where you were actively involved in it throughout the course of your marriage, and there were efforts that you put towards it that increased the value of it. So art is one of those type of asset classes that is almost always predominantly market forces driven in terms of the appreciation of it. And I thought that was something that when you think about the type of assets that are considered non-marital and marital, art's one of those that is, because it can be traced to when you acquire it, usually doesn't have anything other than market forces that appreciate the value in it. So there's never really the concerns about commingling or transmutation, other than perhaps the insurance cost that you put towards it and things like that may be a credit in divorce.
But I think what's interesting and what you can see in some of the cases is the discussion of where you can see the arguments for what people have done. So the spouse who went to every gallery show on the weekends, or the spouse who organized the loans and the exhibitions, which could arguably raise value. And so you see that as factors that then can be used and be at play. But because we're on schedule, let's move to valuation, a topic near and dear to our audience's hearts. So Samantha, how is art normally valued in a divorce? Why is valuing art in a divorce often uniquely challenging relative to other assets?
It's subjective as compared to, say, a bank account, right? You look at your bank account statement, you know how much is in your bank account, each of you gets half. Art, you don't necessarily, it's not that easy, right? And it reminded me of a case that I had where one of the spouses wanted a piece of art, and the other spouse knew that that spouse wanted the piece of art, and so they demanded a premium, far above any of the appraisals that had been received. So it can be used really to one spouse's advantage, which makes it uniquely different than many assets where a house is a house, right? You divide it up based on appraisal. A bank account's a bank account. So I think that's one of the challenges.
And that speaks to the emotional component.
Absolutely.
Like the one spouse wants to live with it, wants to appreciate it, the other spouse knows. That's a tough bargaining chip.
And the Maclau case is a perfect example of this. So how many in the audience know about that case? Yes, mostly everybody. Okay. So by far the most extensive discussion of art in a divorce to date. Incredibly, incredibly interesting in all different aspects of the equitable distribution process. So we were just talking about the first part of equitable distribution of property, right? Which is Is it marital? Is it separate? The MacLeod case was straightforward in that both parties agreed all of the art was marital property. They really did build a life and a vast fortune together. The second factor in equitable distribution is then valuing the marital property. And as Samantha said, in many different cases, or for many assets, valuation is simple. An investment account in publicly traded securities is going to be what are those securities worth? A house, yes, it does require an appraisal, but it's typically much more straightforward. The more difficult to value assets are closely held business interests and art and other tangible property. So in the MacLeod case, both sides had very reputable appraisers. I believe Winston Art Group and Gurjans were on either side, and yet the values that they both followed standard protocol in terms of valuing the art, and yet they had swings of, in some cases, millions of dollars. And the opinion is fascinating because it goes into, well, should we only have looked at public auction sales? Should, one of the valuation experts was pretty rigid with that. The other one looked at private sales, and there was a lot of discussion there. And the other piece of the valuation, which is somewhat unique to art, is how do we account for costs of sale? So in going back to a publicly traded security, putting taxes to the side, capital gains taxes, the price of the security in your Fidelity account is going to be very similar to what you then receive less commissions, because the commissions are very negligible. As Magnus just said, you might see a 27% decrease in what your art is worth versus the cash you actually receive for it. So one of the questions in MacLeod was, do we look at the fair market value, which is the value that a willing buyer is willing to pay from a willing seller, none of whom are under the compulsion to buy or sell? Or do we look at the marketable cash value, which is the fair market value less the costs of sale and potentially less the costs of taxes? Judge Drager, who was a very seasoned matrimonial attorney who has since retired, who wrote the decision in MacLeod, decided to use fair market value. Not surprisingly, Linda MacLeod, who wanted to buy out the art, wanted the marketable cash value, the lower value, so that she could pay Harry less for the art she wanted to keep, and Harry wanted to use fair market value. Judge Drager ultimately determined that fair market value was what was fair and appropriate in this situation, because Linda did not actually intend to sell the art and would not see those costs of sale. So, there's so many different issues in the art world, but I think there's a Florida case that actually showed a different and used more of the marketable cash value. So each state, and again, going to why it can be such a confusing mess for collectors who have homes in various jurisdictions, is you might see different opinions in different states about how to appraise art and the different methodologies, and then also, do we, cost affect it and tax affect it or not?
So on that, Daniel, Samantha, what do you think from your respective jurisdictions, since MacLeod is New York, what's the interplay there? What do you think?
I think the evaluation of how it works is very similar. I mean, how is it going to be appraised? Is it part of a collection? Is the collection more valuable than the individual pieces? I think that I agree with everything Alyssa said and the complexities of it, really.
Yeah, and I think, again, you have 3 different states up here, and each state is different. But I know from the 3 states that are up here, the approach to valuing assets is consistent, which is essentially fair market value, willing buyer, willing seller. There is always the argument when you are trying to retain the asset that the cost of sale should be considered, the embedded capital gains, the potential closing costs. However, a hypothetical sale is almost always disregarded by a court. They say, unless there is a sale that you can say what the actual trade is, the actual value that's set by a willing buyer and a willing seller, there's no way other than using the tax rates applied to this hypothetical sale and perhaps what you would pay in closing costs or a broker or things like that, that would translate into the ultimate value. So frequently when you're in the divorce process, you have one person who's saying, I want to retain an asset, and the other person saying, perhaps, I want to sell it. And the person that says they want to sell it sometimes has some greater leverage because they know that they can essentially get a better bargain because the person that wants to retain the asset may pay a premium. And there is this frequent argument that hypothetical cost of sale should be considered, but they are frequently not.
So marketable cash value as an appraisal tool often does not win the day. Fair market value carries.
Yes.
So I think that's an important, relevant takeaway. Moving to the next point, which is important in Florida, Daniel, can you explain the role of the fiduciary accountant and the accountant's role in the divorce proceedings from a Florida perspective? Ooh, I don't know.
This was actually, for me, the biggest difference as I transitioned my practice from New York to South Florida was that in New York, very infrequently, you are using accountants other than for the purpose perhaps of a specific valuation issue or perhaps a lifestyle analysis or something along those lines. In Florida, it's much, much different because you are frequently having mini trials within a case and you have to have someone testify on your behalf or your client's behalf who has the acumen, who perhaps isn't the spouse who doesn't know credit card statements or financial documents or how to explain coherently what their lifestyle is. So from the beginning of a case, essentially in Florida, you're retaining an accountant. Accountants are a big component of Florida divorces. It just is what it is because you want somebody who has that acumen, who has the ability to explain things clearly to a judge in a very short period of time and try and win your case or put your position forward in the most cognizant way. When we were talking on our panel, it's not in every state that happens, and there are appraisers and professionals in the room that may not know that in Florida it is a very accountant-focused state. So the relationships that people establish in different professions with accountants can be quite valuable because the accountants are usually the ones who are saying, we need to value this. We need to, I have a resource. I know somebody that is good at doing things like this. And so when we were planning for the panel, the reason that I think I was keyed to talk about this is that for those of you who don't have relationships with accountants in Florida or do work in Florida, it's certainly in terms of a networking or to expand your reach, it would be a good thing for I think the professionals in this room to do because the accountants are quite useful and a major resource in Florida divorces.
And what do you mean by, we were trying to give practical tips from an appraisal perspective, so that was one of them. Daniel, what do you mean by mini trials within a case in Florida?
So different than New York, where you're really only having a trial at the end of a case, or if there's some issue that a court says almost on an emergency basis, we need to have an evidentiary hearing. Doesn't happen in New York. I can't really speak for California, but in Florida, you have trials all along the way. So if you say, I need to sell something, or I need support, or I need counsel fees, you are able to say to a court, give me a hearing. And it may not happen the next day, which is different than New York in that you can't get into the courtroom as quickly in Florida. But once you do get into the courtroom, you're able to have an evidentiary hearing. So you put a witness on, you put an accountant on, and you have a mini trial. And so I guess that's the way.
That's the answer. Okay, thank you. Alyssa, can you explain the different theories? I mean, we talked about this a little bit for MACLA, so we might have it covered, but anything about the buyout value for art or anything else you want to touch on the costs?
Yeah, I think we covered most of those valuation issues through MACLA.
All right, let's move on. Distribution. How is art normally distributed in a divorce? Daniel, we were going to start with you, but since you just talked about mini trials, Alyssa, you want to take that one?
Sure. So going back to the Maclau decision, but backing up and generalizing even further, there are, as we talked about, the 3 steps for the distribution of property in a divorce. So we touched on the first, is it marital, is it separate, in states that distinguish between the two. Second, valuation. Third, distribution of property. So one of the issues, and something Amanda touched on in the beginning, is if you were in a state like New York, unlike California, Samantha will talk about California, we are an equitable distribution state, not an equal distribution state. So that means that assets do not need to be split 50-50 equally. And courts will sometimes treat different assets differently. So theoretically, I have not seen it in a case, if you had one person who did all of the work to source and find the art collection, could they have an argument that their contribution to that asset would mean that they should get more than 50% of it? Maybe. Again, I haven't seen that case. But that's a lot of where what Amanda was talking about would come into play in terms of arguing about contributions to different assets. Because the reality in New York is that even though we're not an equal state, in long marriages or marriages with children, most assets, except for privately held business interests, are divided equally. And courts often default to that. So we don't spend a lot of time arguing about, oh, I should get 60% of this asset versus 50% of this asset, although it does sometimes happen. So I put that out there. The more important issue in the art world and divorce is, are you going to have a buyout or are you going to sell the piece of art? Or theoretically, are you going to keep co-owning it? Right? Those are the choices when you're looking at in a divorce as to how to distribute art. So the Maclau case was very interesting because Judge Drager actually did both. So for the pieces of art where there was a very, very, very long list of art, and for the pieces where the 2 competing valuation experts either agreed on the value or came very close, Judge Drager just averaged them, which is not typically done, but she argued that that was the right result in that case, and then allowed Linda Maclau to buy out her husband and keep those pieces of art. Even though I believe the value of the art she was keeping was about $500K, there were a lot of pieces, but it was a relatively small piece of it. For the rest of the collection, the judge ordered a forced sale of the art, even though Linda, what she wanted after that trial was to be able to buy out her husband at her values. The judge still ordered a forced sale. So what is a forced sale? A forced sale is exactly what it sounds like, where a judge says, I am ordering that this asset is sold. It does happen in divorces when parties can't agree, for example, on the value. So you'll sometimes see a forced sale of a home if you can't agree on who will buy out whom or what the value of the asset will be. And for the majority, some newspapers claimed it was all of the art collection. That's incorrect. As I just said, there were some pieces where Linda did buy out Harry's interest, but for certainly the majority of the value of the collection, that was sold. And to date, it was the largest private sale as of that time. And I believe it came in at north of $900 million. And the reason that Judge Drager gave to force that sale is because of the difference in value, and also because it was one of the largest marital assets and the parties needed the liquidity. So that was a big part of it, that there was a huge lifestyle, huge expenses to keep up, and many other assets to have a buyout or division of, and it would have been difficult to do that if Linda were allowed to purchase her husband's interest in all of the pieces of art. So there are advantages and disadvantages to having forced sales in cases. And certainly for your clients who have huge sentimental value for art and huge emotion, a forced sale can be absolutely devastating.
It can also be devastating for the artists themselves.
Yeah.
I'm involved in a case right now where essentially a forced sale, one of the parties is arguing that that will completely devalue the artist's work themselves, because you acquire a certain number of specific pieces and you're not supposed to. I mean, I'm not an expert in this, you guys are much more versed in it, but the things that are being said are, in essence, you can't just force an immediate sale because of the impact that would have potentially on the value of not just your artwork, but the artist's reputation and the artist's other artwork.
A lot of the times in appraisals and in these valuation discussions, we'll talk about a blockage discount. And that goes to the point. If you have a block of one artist, you really collected, I don't know, Damien Hirst or whomever, and then you have a forced sale in a divorce, those are the types of arguments I think we would see, and those are what would come up in a valuation by the appraisers.
Yeah, we're at the point in our discussion where we're talking about distribution. I think when conceptually, if you want to think about how property is addressed in divorce, you take the 3 steps that we're kind of talking about. How is it classified? How is it valued? And then how is it distributed? I think that when you go to that first step of classification, if it's non-marital or separate property, it's going to the party that is the title holder and nothing else happens. But if it falls into the classification of being marital property, then as we were talking about, you value it and then ultimately distribute it. And there are, as we've sort of touched on, the implications and the different positions that you can take vis-a-vis a distribution.
Just to add one point to that, I think that one of the things we haven't talked about is not just the collector, but the artists themselves. In terms of the sale of the asset, whether it's separate or community, it's the same process, the 3 steps. But what if a sculpture is not done yet? What if we don't know how much more there is to do with it? What if there's a sketch of an idea, but there's not anything that's been produced from that sketch? What if there's just an idea? How do you value any of those things? What is the value? Well, to the artist, it's that this could be their future, pivotal work. To the spouse, they see value, and they want a chunk of that effort because it came from efforts during marriage. So you really have to distinguish between those 2 situations, because you have to approach them from completely different angles. You are the artist, you've created things, pieces of art during the marriage, or you're in the process of doing, what happens then? And
Samantha, that's such a good point. And what about the IP? So there's the physical art, there's the IP, you have maybe one spouse, a lot of times artists are married to each other. So, and maybe liquidity is an issue. I don't think we have a case where we had a forced sale for 2 artists whose inventory we were dealing with, but you can imagine the issues that would be at play in such a situation.
There's also the difficulty with assets like art in essentially tracing it, because unless you have the records, to actually find the inventory or the actual pieces, there's a lot of mischief that can happen in a divorce as to exactly where the pieces are, whether they still exist, when they were acquired, and things like that. And it does present a difficult issue in a divorce process, trying to make sure that you can identify all the artwork that exists.
Of course. Okay. So the titling issue, we have a little segue now, and we wanted to move from these perspectives to understanding how we can mitigate art risks in a divorce. And some of the tools in our toolbox are things like prenuptial agreements, planning as part of your estate planning, smart lawyering generally. So I wanted to say, I remember talking to Samantha while we were planning, and Samantha said something about a story about how people can hold things, et cetera. So in LLCs and different structures, instead of just going out and selling as part of a divorce. So Samantha, I wanted to give you the ability to talk a little bit about that anecdote to kick it off.
So I had a case where there were smart lawyers who were involved, and there was a significant art collection, and instead of holding it in their individual names, they held it in the name of an LLC. That's a good reminder of that story. Well, one of the couples, one of the parties, they valued the property so highly that they wanted to retain the entire collection, and they wanted to be awarded the LLC. And what was so significant about this and unusual was that the house, the family home, is where most of the artwork was being stored. It was on the walls, there were storage units, there was the whole 9 yards. And at the end of it, the spouse who wanted to retain the art was actually not the one who stayed in the family home. And the question became, well, what happens to this art then, right? The spouse who was going to retain the home didn't want suddenly everything on the walls gone. So they came to a unique agreement where one spouse retained the house, the other spouse retained the art collection, and was allowed to, the art collection stayed at the house until that spouse sold the house many years later. And so it was a unique way to divide art. I've never seen it done before. I don't think I'll see it again, frankly, because how often do you have collectors, serious collectors, who don't want to see their artwork, right, one way or another, whether on right, in a gallery, in their homes, whatever it would be. But for some reason that worked. And I think part of the reason ultimately that this worked is also because it was held in a very secure way. There was inventories, there were bills of sale, there were all these things, so you could track it over the course of the years and know if a piece went missing suddenly. And so I think that the structure of it, the formality of it really lent itself to this type of situation, albeit very, very unusual.
Alyssa, so going to prenups, what tools are in a couple's toolbox when thinking of getting married? How should art be treated in a prenup? And picking up on one thing you said that I thought was very interesting. Oh, I have to announce the CLE information. It's up here, family 34K. What is considered a long marriage? You mentioned that. Long marriage versus short marriage, because I'm not a family lawyer, but I understand in prenups there are different like thresholds or time lengths, or you meet certain conditions, precedent. What do we have to be thinking about long marriage, short marriage, medium term?
Yeah, that's a good question. There is not a threshold that's in the law. I think, and I'd be
Depends
curious
on the
what
case,
Daniel
right.
and Samantha
It depends
I
on-
would say a marriage
depends
of
on who
10
you're
years or
representing. No.
more is a longer marriage. I also think what having kids is often sort of a turning point in how courts divide assets. So I would say 10 years, but there's no hard and fast rule. It's all argument, right? So you could say a 7-year marriage is a very long marriage. I don't know. Daniel, Samantha, do you?
In California,
It doesn't really matter in California. It's not
well, it does for certain purposes, not in terms
for
of
maintenance and alimony.
Yes, for spousal support or alimony, it matters. For division of the assets, it does not matter. For the enforceability of a prenuptial agreement, it doesn't matter. So, and the line of the rule is really that if it's a 10-year marriage or under, then it's a short-term marriage, and if it's 10 years or more, it's a long-term marriage. But you see people getting divorced when they're 40 years old and they're in the prime of their career, or they're on an upward trajectory. It's not the same analysis sometimes when you have a 10-year marriage and you got married later. So, but either way, it doesn't matter in terms of the division of the assets. It's not based, there's no equity that comes into play. It's just divided 50-50.
So I'm smiling because in Florida it's statutory. So it's actually, the law says what are considered a short-term, a medium term, or a long-term marriage. And the reason I'm smiling is because you have 3 different states up here, and they're all different. And so that's important in when you're talking about these type of issues. You need to get advice from somebody within that specific state, because it's all different. So that was, as you know, I talked about a little bit, transitioning my practice or being in a 2-state practice, New York and South Florida. You understand the nuances, because you can't just say, well, how do I think about it under this, you know, the way that I was taught in New York. You really have to understand the state-specific issues and state-specific statutes and how it applies. So I think that's important for, you know, the entire group to understand that it really is where you are situated, and where, if you're going to get divorced or you're going to do some type of prenuptial agreement, which we'll talk about in a second, you have to get advice from that specific state lawyer.
Yeah, and so going to, you know, I think we may have scared a number of you about all the complications of a divorce. And so what are the solutions? Well, a prenup or a postnup, it doesn't have to be before the marriage, is a really, really excellent tool. So a prenup entered into before the marriage, postnup can be identical, but entered into after the marriage. In New York, both are enforceable, and both are excellent ways to be protective and to have clarity and not to have an absolute mess of a divorce. So going to those 3 stages of equitable distribution, a prenup can address all of them. So a prenup can very clearly state what art or what any asset is going to be separate and is going to be marital. And then it can have a very clear mechanism for how we value the marital property. Do we take out costs of sale? Do we keep them in so that there's no argument? And then it can also dictate, well, who gets to keep any type of marital property? Who has the right of first refusal? How do we determine whether a piece of art is going to get sold? And you can be as specific and as detailed as you want to be. One thing to note, another case in New York, Anonymous versus Anonymous from 2017, is that even if you have a prenup, you need to be incredibly careful about how you define terms. So who's heard of the Anonymous case? Anyone? Oh, yeah, good. So in the Anonymous case, there was a dispute about art when there was what I call a title controls prenuptial agreement. So in a title controls prenuptial agreement, unlike the default law in New York, it's not about the source of funds to acquire an asset, it's simply about title. So that dates back to prior to 1980, when the only thing that mattered was the title of an asset. So as I was just saying, in New York, you can't make something separate property by just taking your earnings and putting it into an account in your sole name. It's still marital property, regardless of whether you're in Florida, California, or New York. But if you have an agreement that says, we're only gonna look at the title of the asset, then that is what is dispositive upon a divorce. Well, in the Anonymous case, there was an extensive art collection and there was a title controls prenup, but the problem was that it was not clear how certain pieces of art were titled. And therefore, there was litigation over whether that art, even with a prenup, was separate or marital property. And the appellate division ultimately ruled that how it was listed on the invoice was not dispositive. And instead, there was to be a detailed fact-based inquiry into each piece of art, which obviously that goes against the intent of having a prenup and keeping everything very clean and easy. So it's also super important in a prenup or a postnup to make it clear with an asset like art, well, how are we determining title? So you could say, I now, because of that case, in my prenups, I actually say, if there is any dispute or if it's not titled, we will look at the invoice, bill of sale, and source of funds to acquire. If you did a prenup that instead of having that strict, what's mine is mine, what's yours is yours regime, and did something that more mirrors the law, you can state, again, going back to let's simplify the classification process, you can say that anything you purchase during the marriage, if it's under a certain threshold, is going to be marital property. So you don't get into those arguments of, well, I used, X amount of my, inheritance to purchase this piece of art. So we'll typically have a threshold so that people can buy very valuable pieces, but you might say, well, anything under 10K or 20K is presumptively going to be marital property. So the beauty of an agreement is that you can make it incredibly bespoke. And if you have clients who are very heavily involved in the art world, you can specifically address individual pieces of art in the prenup and who gets them, how they're valued, whether or not, and to avoid the situation of having a forced sale if somebody doesn't want a forced sale. You could say that the art will be co-owned or put into a trust for the children. You can do anything you wish to do. So if there's one takeaway from here, it's hopefully if you have clients with extensive art collections, that they should be really intentional and deliberate about how they plan for it and thinking about it upon divorce or upon death.
And from a human perspective, given these conversations are so hard, how do you navigate people to have this kind of rational conversation during a marriage as they're collecting art? And what type of collectors do you see that are able to have these conversations and do this type of planning versus people who you think, oh, you should have? How do you counsel clients on this across the board? Hard question.
Oh, so back to me? Okay. I'm happy for Samantha or Daniel.
Yeah, I was looking at Samantha. I was happy to jump in.
Go
no,
for it.
I mean, I think that there's different stages, obviously. There's the stage prior to a marriage and then stage when you're in a marriage. I think prior to a marriage, whether you're a parent or an advisor or somebody who has acquired a significant net worth and has professionals in their life they should be giving, professionals should be giving guidance and saying these are conversations that you should have. These are communications and ways of thinking that you need to be transparent about. Because if you don't, it can cause problems. And so sort of touching on Alyssa's point about prenuptial agreements, it's like, why? There are certainly situations where prenups are not appropriate, but in many situations they are. So when someone calls me and explains they're getting married and they're thinking about a prenup, you sort of discuss with them why they're doing it. What's the purpose of it? You know, to protect either things that you have, things that you may inherit. And that's, in essence, the purpose of a prenup, to put parameters in a written contract around assets or issues of spousal support, estates, things of that nature. Also sort of touching on what Alyssa is saying, you also have to be careful because you're putting a contract around issues in your marriage. And so a contract is going to be interpreted by a court. You don't go beyond that. It's not the equitable distribution law in New York, equitable distribution law in Florida, or community property in California. You've basically now contracted your rights away, and that's what's going to apply. So you have to be very careful when you enter into prenuptial agreements that it's very clear. To Alyssa's point, you have, you know, how are you going to classify when title for art, for example, if there's a dispute, bill of sale, things of that nature. You have to be really careful, otherwise there can be a ton of mischief that can be created if you have a weird or wonky prenup that is inconsistent internally, and you know, issues arise in that way. So I think one of the important things to think about, in addition to why you would enter into a prenuptial agreement, it's also, you have to be careful, you have to get good advice, and these things can be quite dangerous if they're not done appropriately.
Just to add, because I agree with what Alyssa and Daniel said, don't put your head in the sand, right? You can't just assume it's going to be okay, or that your spouse is going to say, you know what, you keep that piece, I know it means a lot to you. You never know what's going to happen at the time of divorce, right? And so you have to encourage clients or prospective clients to have those hard conversations and to really put forth their goals when it comes to getting married and provide for that orderly distribution. We talk about the fact that modern couples now don't find them to be as taboo as they used to be. And this is across many cultures all over the world, you know, and so have that conversation, have that hard conversation. Listen to your advisors, listen to your lawyers, listen to your business managers, listen to your accountants, listen to whomever it is who you take advice from. And really remember that those hard conversations are going to happen whether you're getting married, when you're divorcing, and you need to have them, because otherwise you're not going to end up.
The conversation's a lot harder.
Yeah, it gets harder and harder as time goes
Right.
on if you don't have that clarity. So prenuptial agreements are a great tool to ensuring that you have the orderly distribution, provided it's very clear who takes title or who owns it, regardless of title. Because as Daniel pointed out, what you're actually doing is you're opting out of the law of the jurisdiction in which you are living, oftentimes, when you're entering into a prenuptial agreement. You're saying, okay, this is an equitable distribution state, but that means I may only be entitled to the value of 60% of a painting or 60% of an art collection. And you're instead saying, here's how we're going to do it instead. But when you're putting together prenups, and I think we're going to touch on this in a few moments, but that orderly distribution concept is really important. But orderly distribution is not only upon divorce. You have to think about it upon death as well. And you have to ensure that both a prenup or a postnup and your estate planning are actually consistent and work together. Because if they don't, that's where problems can arise as well. What happens if you die during marriage and in your prenup it says one thing and in your estate planning it says something completely different? Who's left to address that issue? So this is a good example of where lawyers need to really work together and put together a comprehensive plan that ensures that orderly distribution, because this story that Alyssa shared is a nightmare. You know, what happens? And the bill of sale the documentation, it disappears over time. There's mischief, right, Daniel? That's your word?
Yeah,
Which is
mischief.
perfect. It's perfect. So
going to that, I think on every panel I've ever been on, I'm always saying, what does the left hand and the right hand in the art world have to speak together, right? The lawyers, the appraisers, everyone, the family offices, the business managers, people should know what's going on because oftentimes there's such a disconnect. So I think Samantha brilliantly said, everyone has to work together. And so if you've got a revocable trust things are being changed, you had an invoice in the Mr. and Mrs. Smith, and then all of a sudden it's paid for from a rev trust or somewhere else, or somehow it's getting into a foundation and nobody knows what everyone's doing, that can create real logistical issues. So what do you all think in terms of, I think it's pretty easy, liaise with each other and remember to bring in the trust and estates and ask those questions. But when the clients come in your door, you saying, who's your trust and estate counsel? Have you spoken to them? Can we do a true up? Can we look at the terms of your estate planning and make sure it works with the post-nup, or make sure you send them a copy? How are you running them through that to ensure everyone's in the know?
Yeah, and I think if you don't have an agreement, if your client's just saying, I'm not doing that, I don't have a prenup, I am not asking my spouse for a postnup, then the answer really is that coordination and good record keeping. Because as we hopefully learned from things that are litigated, a lot of it comes down to he said, she said, paper trail facts. And as we also said, it is the burden of somebody who wants to show this is my separate property to prove that. And it can be incredibly difficult. So as a family's advisors, I think the responsibility is on making sure that the appropriate records are saved so that if a piece of art is gifted, okay, is there a gift tax return? Is there a record showing that this gift was to just one side of the couple as opposed to both of them? You want to try to avoid as many issues of fact as possible if that couple gets divorced. And I think as advisors to the families, they can absolutely help to just ensure, hopefully they never need it, but if they do, the records are there.
It's also, understanding the things that you don't know. And if you don't know it or you don't specialize in it, you should call somebody who does. I think that, how do you sort of liaise? It's you identify issues that come up and you say, this is not my specialty. There's a huge amount of synergies in our field, I think, with trust and estate lawyers, because we encounter those type of issues very frequently, and we don't do trust and estate law. And frequently trust and estate lawyers, although sometimes they do prenuptial agreements, they don't do family law. And so it's understanding the questions that you don't know the answer to and being able to ask. And I think that's the most important thing, because if you don't, or you don't give guidance to the people that you're working with to ask those questions or to get a referral to somebody who might have the answer to them, it can cause a lot of problems later.
One point that I have two follow-up questions to you all. One is, we didn't talk about gifts during a marriage, and I think you hear about that all the time, not just with art, but across the collectibles categories. I can think of how many spouses are gifted Birkin bags, how many spouses are gifted jewelry. How does that come into play? The collectibles market, I think what we're all saying is it's really dynamic right now and really growing, and we expect that to see that. How do gifts in the marriage get treated?
So gifts, if it is to one person, so gifts between spouses in New York are marital property. Although in prenups we will often say it's separate because it does feel kind of tacky to value a piece of jewelry given to you by your spouse and ask for half of the value back. But under the default law, without a prenup, if you receive a gift from your spouse, that is marital. If you receive a gift from a parent or a family member, that is separate property. But again, the burden is on the person asserting that it is separate property to show that. So going to Amanda's question, we've had many disputes and fights over whether something is a gift to both parties or is something a gift to one party, and what kind of documentation do you have for that? So kind of going to what I was saying before, is there a gift tax return? Is there a gift letter? Is there even just a note saying, honey, I want you to have this Picasso because it's your 30th birthday and it's just to you, not to your spouse. Hang it in your, just kidding. But that can often become difficult. So I think counseling clients that if they are gifting art, to make that clear if they don't have an agreement could be really helpful.
So I'm involved in a case. I'm waiting on a decision. where my client's wife was gifted purportedly a piece of artwork from a artist that she had a relationship with. And
Florida or New York, Daniel?
I'm not going to say. And to sort of, I guess, deflect some of the arguments that were being made during the case, she claimed that she was the artist's muse. And so this was given to her because, as a gift, because she was a muse and she had, helped the artist and counseled the artist, and she in return received this piece of art, which is quite valuable. And the argument that I made, I'm not sure I'm going to be ultimately successful, is that it wasn't a gift only to her. In fact, it was in consideration for the work efforts that she performed during the marriage, and therefore it should be classified as marital property.
The muse and maybe more.
Muse and maybe more. But so anecdotal, I'm not sure how it's going to come out. I don't know that it's the best argument when it says to this person on the back of the piece of artwork. But yeah, it goes to everything we're talking about, which is you want to be careful with especially valuable assets, how you address them, and if they are gifts, which are traditionally, can't speak for every state, I know for the 3 states up here, a gift given to somebody can be excluded, I think in California as well, no? Mm-hmm. Yeah. So you want to make sure that if there is gift giving or inheritances and things of that nature, that it's appropriately papered.
So what you're saying is keep all the holiday cards.
Yeah, 100%.
Keep the gift cards, keep the holiday cards, and the birthday cards. Okay. We only have a few minutes left, so we're going to move into smart lawyering. We all hear about courts being congested. So, Samantha, how busy are the California courts? I think I listened to a podcast and I was hearing people should be looking for alternatives, mediation, arbitration. What should people be thinking about if they want not a long, drawn-out divorce?
Don't ever go into the public court system. It is bogged down. There are not enough judges. They're inexperienced in the family court. It's a stepping stone for many judges into other areas. Use private judges to help mediate cases. Use lawyers to mediate cases. You can even hire retired private judges to help make decisions, not just mediate cases. And it's critical, particularly with a high net worth crowd. They don't want necessarily all of their private business to be public. And in California, everything's public, but you can protect families from some of that by using private judges in a variety of different ways. So I think that answers the question.
Yeah. And how do you, in the case anonymous versus anonymous, how are they able to stay anonymous, Alyssa?
That's a good question. It is incredibly difficult to get an anonymous caption. It's not just that you're famous. You have to show that it would seriously harm maybe the children in the action. So what courts often do is they will, if there's something salacious in the decision, they will initial it. So it might be like JR versus, NR or whatever it is. And then anonymous captions, really, really difficult to get. But unlike, and I think this is not like California, in New York, unless it's a published decision, you cannot find out details of filings in New York, which is good. So it's not sealed, but you can pull up captions. Like, when you see the divorces in page 6, you'll be able to find out. It's like, as soon as you file, somebody will say, so-and-so filed for divorce against so-and-so. And then most of what they pull is just from the public record. So you can't get in New York what was in the summons and complaint, or if somebody files a motion in court, you can't get that underlying motion. It's not publicly available. It's only available to the parties and their attorneys. But if something is very sensitive and there's going to be a published decision, it is possible to get an anonymous caption. In California, you can get more than that, right?
In California, the concept that you could have anything sealed, it's near impossible.
When I've Googled California cases, you can find out
lots of
worth
details.
Of people.
Same in Florida.
Totally salacious.
It's all
details.
public. And even in New York with anonymous captions, sometimes that's a double-edged sword. Because if you see, the county clerk sees an anonymous caption, I mean, usually they might call page 6 and be like, what's going on?
Well,
but it is, sometimes you have to be careful as to the relief that you see, certainly in New York, but in Florida and similar in California, everything is public.
The power of the media and on the legislature cannot be understated. I mean, look at the TMZs, look at the Us Weeklies. There's a reason why they have so much information. And it's because the media has so much pull. And in California, that means a lot. I mean, it's Hollywood, it's all of those things. And you read it all over. And it's really disturbing, particularly where you're talking about high net worth families, where it does sometimes put children at risk. They become targets potentially. So you have to keep those things in mind, and going a private judging route certainly can protect families.
Yeah, and I completely agree with Samantha. The New York, it's very similar. The courts are totally overloaded. They have few resources, not very much time. And my preferred method now to resolve cases, if it can't be resolved through negotiated settlements, is to use a retired private judge. And to use, it's more typical to do it as mediation, but you can also have them arbitrate and make the decision. You're going to have the privacy. You'll have more time with that judge because they're not dealing with 20 other different matters that day. And it's going to be much more civilized. You're going to have something that you have one full day that is devoted to your case, as opposed to trials in New York. You could have 3 hours one day, and then 2 weeks later, you have an afternoon, and then it's not consecutive trials. So in my opinion, the court system is really last resort. Judge Drager, who decided the Macklow case, she now does private judging. So if you had a case that involved art, she might be a great person to go to because she obviously has an extensive knowledge of that. So if you have clients who have high net worths and can afford the differences, you have to pay for a private judge as opposed to the free court system, but it makes a huge difference.
Yeah, I think conceptually, the way I like to think about it, and certainly the way that I counsel clients, is when you go into the court system, it's sort of like a meat cleaver. You're going to get the judge that you get on the day that you get the judge, and they're not going to take their time. I mean, they'll be thoughtful and reasoned, and they're good judges, but they are frequently not going to take the time to very carefully address certain issues, where if you do private mediation or arbitration, you have the ability to sort of have it be more like a surgeon and not a meat cleaver. Take the time to carefully address the issues that need to be addressed thoughtfully, and not have to worry about at 4:30, the courts are going to close, the court officers need to leave, and you're going to lose your court day. You have the ability, I think, and there's a shift. Certainly in New York, it happens in Florida, to doing that in the higher net worth cases, just because it is it's a more careful approach to dealing with these cases.
And I think that's what our clients in our market always looks for. We've got these sophisticated clients, they're sensitive information, they're extraordinarily private, and they have some of the masterpieces of our time, and they want to be treated with that type of white glove service. And I think it'll be interesting to see if in this private judge realm, we have this group of private judges who develop an expertise in our industry and are able to address divorces with a lot of sophistication when working through them, in the way we've seen arbitral groups be focused on the art world. So that's something maybe to come. And that ties to my last question, as we only have a few minutes left. Where are we going to be in the next 5-10 years? What are trends coming our way in the divorce world that we should know about in the art world? Open to you, Alyssa.
So I think hopefully more prenups, more post-ups, as I think we already mentioned, that is becoming more common, much less taboo, and people can really customize how they want to manage their affairs. I think it will be very interesting to see, even if there are disputes, are those made easier because of the trends in the art world and NFTs, and having more ease with potentially titling art and also understanding its provenance. So
Prenups are just becoming more and more popular. It was not just for the high net worth individuals. It's not just for today. It's for the entrepreneurs who have a vision of their future. It's for a lot of different people, and I think that it just becomes more and more socially acceptable and less taboo as time goes on. So I think that's certainly a trend in our practices, and will continue to be very important for asset protection, because that's what we're really talking about, right? How do we protect these assets?
I mean, it's hard to follow those 2 points because they covered essentially, you never know what's going to happen. And things are always changing. To Alyssa's point a couple times with NFTs, crypto, things like that. There are things that are harder to address because we don't know that they exist. But I think certainly in the almost 20 years that I've been practicing family law, I have seen an evolution into far more collaboration between professionals dealing with planning, whether it's pre-divorce, prior to marriage or during a marriage. And it's helpful. You know, I come back to, if you don't know the answer to the question, you should find the person that, you know, give the guidance to the client to find the person that can answer it. Don't ignore it, because ignoring things can make things far more difficult later down the road. And, you know, I've sat in many meetings with many clients where, you know, they're sort of saying I shoulda, coulda, woulda if I had gotten that advice, or I had known that, or I'd kept records. And, you know, you can't put that ketchup back in the bottle, which is kind of what I always say. It's like, it is, at this point, it is what it is. You need to move on. But I think that yeah, the trend is definitely moving more towards ensuring that you have the conversations, you collaborate with professionals, you do the appropriate planning.
So we're all on notice. I would like to thank my wonderful panelists this morning and the Appraisers Association. Thank you so very much.
Fantastic panel. Thank you so much, all the panelists. We're going to take a break now, and I just ask you to come back at 11 for our next panel. Thank you.
What? I'm coming up next.
Oh, got it.
I have a question. Hi. I'm also a lawyer. And actually, I'd like to reach out to you that so, you know, I've bought art in various ways, and I want to just specify that, first of all, this body of art is mine, and my spouse agrees to that. Can we just do a schedule with, you know, say, you know, yeah, exactly, an inventory, basically, without even having to prove how it was acquired.
These pieces are my separate property, and
our next panel, I'm just going to ask everybody to grab a seat so we can get started again.
I think so.
Okay, so our next panel is titled Exhibitions, Insurance, Legal, Shipping Considerations. The moderator for this panel is Anne-Laure Alouhat, counsel at Patterson, Belknap, Webb, and Tyler. Anne-Laure's client base includes advising collectors, family offices, museums, galleries, dealers, and artists in a wide variety of complex and high-value art transactions. She draws on her experience as a former Skadden M&A attorney and Sotheby's Senior Vice President to strategically advise her clients on commercial art-related matters. I welcome you, Anne-Laure, and the panelists.
Thank you. Thank you, everyone. Good morning. First and foremost, I want to thank the Art Appraiser Association for spearheading this Art Law Day, giving all of us the opportunity to discuss loans and exhibitions of artworks. And thank you to all the attendees. It's great to see so many familiar faces here in the room, and also to have so many people attend online. Today, I'm fortunate to be joined on this panel by some of my most amazing colleagues and friends in the field, who I'm sure do not need introductions, but I will do so anyway. But I promise to keep it brief. So Tanya Lane is the Chief Legal Officer at Gagosian here in New York. Amy Lamberti is Associate General Counsel at the Metropolitan Museum of Art. Alexandra Kelly is the Head of Business Development at WOVO. And Kirsten Johnson is a fine art insurance broker with Risk Strategies. So we have their amazing experience to draw upon for our topic today. So the United States has had a very long history of programs in place, like artifact and indemnity programs, immunity from seizures, to encourage the loan of invaluable artworks. Those artworks might otherwise remain unseen from the public, and they foster a societal dialogue through the arts. Protections of this type have allowed institutions to present extraordinary works. However, there's been some recent events that have posed new challenges to this mission. The past year, climate activists have targeted iconic artworks to draw attention to the urgency of climate action and provoke their own public discourse about environmental crisis. In 2022, in 2022, activists threw tomato soup at Vincent van Gogh's Sunflowers at the London National Galleries. A few days later, different activists threw mashed potatoes at Claude Monet's Les Meules at the Barberini Museum in Potsdam. And these incidents, though intended as symbolic acts to convey the urgency of climate crisis, bring up some serious questions about security and accessibility of our most treasured cultural artifacts. So we will examine, with this help of this panel, whether those types of events will impact the willingness of collectors, artists, and institutions to loan artworks to exhibitions. With these questions in mind, I wanted to turn to our panel to delve into exhibition and hear from their experience and draw on their expertise to discuss loans and security concerns, and whether security concerns might affect, oh, that's a lot better, thank you. So whether the security concerns affect their approach in getting the exhibition and loans together. So first of all, I wanted to ask maybe Amy and Tanya about the key considerations they look at for an institution or a gallery when putting together an exhibition, and how far in advance do they get involved?
Good morning. It's really great to be here and see so many familiar faces. I apologize in advance that my voice is a little in and out. So I work in the counsel's office at the Met, and so I'd like to say that I think from the curatorial perspective, for them it's an ideal exhibition if they really don't see me much at all, or if they maybe only see me in the process of applying for immunity from judicial seizure for foreign loans that are coming in for temporary display. Generally at the Met, curatorial drives the exhibitions program, as you might imagine, and the curators are the ones who are out there negotiating with the lenders and laying the groundwork, 3 to 5 or even more years in advance for big shows with many international loans, or sometimes 1 to 2 years in advance for different types of shows. So from my perspective in the council's office, we get involved sort of routinely on exhibitions when there are international loans, and we can talk more about that. We also get involved when you talk about things like thinking about strategically the climate change activists and what kind of precautions that we can take to ensure that our lenders are comfortable sending their most valuable possessions to us. And so one thing that we've developed over the years is a set of visitor guidelines. That sort of is our contract with the public. It's how we ask people to behave, although we don't like, well, I'm fine with saying we want people to behave a certain way, but we also want to be very welcoming. And over the years, we have a list of things that aren't permitted, and that's a way that we take, even before people come in the door, they can't come in with big banners or paint or other things. So that's just one thing that comes to mind that we do sort of on an exhibition by exhibition basis.
And Tanya, do you take 4 to 5 years to put an exhibition together?
No, it's when Larry said so. I would say it depends on the artist, right? I think our artist liaisons have a strategic plan for their artists, and they have this idea of what they want to do with them in the next 3 to 5 years, if they're going to participate in exhibitions, where they are in their careers, how we want to develop their market. But we certainly have a very short time window in pulling together exhibitions. We have specialists who meet, they discuss what exhibitions they want to put on for their artists, and we think about what that looks like from a global calendar perspective, because every single location has to be planned. It has to make sense for the jurisdiction you're in, it has to make sense for the artist, it has to make sense in connection with the auction calendar, art fairs and the like. And so an exhibition could be something that's on a horizon for a year or two, or it really could be, Larry wants to do this, and we have the time and space and capacity to make it happen.
And Tanya, do you think that galleries have a different goals when they put together an exhibition of an artwork versus a museum like the Met? Is there a commercial component to it?
Okay. There's always a commercial component for a certain aspect of our exhibitions. I think if I think about my history with exhibitions, I must think about my time at Sotheby's, which was over a decade. And I like to tell people when I moved over into the gallery world, it felt like a different market completely, because when I was at Sotheby's, I tended to think about the collectors more so than the art itself. And that changed. I had the experience of being, I think, at a museum luncheon, and I was talking to a lawyer on the right of me, and I looked to the left, and there was an artist sitting there. And I just kind of stared at him for a while, because I hadn't thought about artists when I was at auction houses. I always thought about the property, the collectors, how do we make this auction happen? And it was very much far more commercial for me and more detached than it is in the gallery world. You are dealing with living, breathing artists, their passion for what they do. And I think that certainly translates with my colleagues. And so certainly we're there to make money, but we also care about our artists. We also care about what stories they want to tell. And so I know that there is this divide when people think about galleries versus museums, but we care as much about the art and the story they tell and the development of the artist as much as we do about selling it, because without the first, you can't do the second. So.
And just to follow up to that question, as you're working with artists alive and caring about their artwork, how far in advance do you plan those? Because obviously you need to have them provide you with the art, right? Far in advance of the loan exhibition, but they may not have the works yet, or maybe
it can be wet. It can be wet. We have times where it's really a wet work. It does. That calendar is, one, the inventory of the artist, how quickly can they produce the art depending on their method, and you don't just rush them. They're not a factory, right? They have a vision. You also have to think about how you want to promote the work. So we have the Gauguin Quarterly, we have a magazine, we think about the press that we don't control. So when you're thinking about the timeline, you're also thinking about how am I going to promote this and what deadlines exist as a part of that machine as well. So.
And Kirsten and Alexandra, how far in advance do you both get involved in supporting the lenders, the borrowers, the institutions who are sort of getting those artworks in place?
So as an insurance broker, we like to be involved as early on as possible. We are an advocate for the client. We work for the client. So we're trying to achieve that they have the broadest coverage at the best price. So the earlier on, the better for us. And as a broker, we're wearing many hats. So we could be representing the gallery, the museum, the collector, perhaps the artist. And even beyond that, maybe we're representing the client from a lending position or from a borrowing position. And our perspective is going to change. So from a lender's perspective, who is insuring? Generally, we always want the borrower to be insuring that loan. They're in control of the property. They understand who has access to it. They're overseeing the security. So that's generally what we're always striving for. We always want to try to get a copy of the borrower's insurance policy, at minimum their exclusions, to review as well. And it's critical for us when we're reviewing that the borrower's insurance is equal to, if not better than, our clients' existing coverage. We never really want our clients to be put in a worse position than the coverage that they're already afforded under their annual policy. And then the conversations really start to develop when we're looking at that contract. So if a client is lending a work to the state of an exhibition in the state of California, if I see an earthquake exclusion, that's going to be a negotiation point to get that removed. If it's a work that's going on an exhibition and it's going directly to the museum, it's not stopping in between, and there's a mysterious disappearance exclusion, while not ideal, maybe that's something that the collector could live with. If it's a sculpture that's going on exhibition and there's a moths exclusion, well, sculptures are generally not very susceptible to moth, so that might be okay. Whereas if it's a textile object and it's going on loan for a year, that could be a deal breaker. So being involved early and having those conversations is extremely helpful, and it makes our client feel quite confident that they're comfortable lending this work. And then when we switch our hats to the borrower's perspective, same question, who's insuring the object? We do see from time to time that a lender wants to maintain their own insurance and not accept the borrower's insurance. And in those cases, it's really important to include in the loan agreement that the lender's insurers will provide a waiver of subrogation. If the lender wants to use their own insurance, that's their prerogative, but we can't hold the borrower responsible for that. And take that even to a step further, which goes a bit outside of our lane as insurance brokers, but requesting a hold harmless agreement. That way, the borrower is not opening them up to exposure for a further lawsuit. Thinking also about the borrower's budget is very important early on. When we have an idea of the total values of the show, we're generally a lot more successful in pricing that out competitively. I love options, our clients love options, so when we have time, we can go to market, get bids, and present really the best price and coverage for our client. Thinking about transits too, if a lender is shipping several items from Switzerland and the total value of those objects exceed the borrower's insurance transit limit, we have a few options to consider. Do we want to increase the transit limit and pay the insurance cost so that everything can ship in one? Or can we split it and maybe pay for 3 separate shipments so that we don't have to increase the transit limit? So again, it's a lot of dialogue, but the sooner the better, and we're very happy to help.
Yeah, I think there's a role for fine art service providers to play in planning, specifically from the budgetary perspective. A shipping quote won't last for 5 years, but it can be directionally correct if they're thinking about potential loans and what those cost implications would be. Think about a New York-based museum that was looking at a wish list, if you will, of objects and asking us to apply some strategic insights into how to minimize the cost of shipment. There was an object in Hawaii, which ended up being a outlier from a financial perspective. So it's helpful for them to have that information, especially as WOVOs become more national too, and we're working with clients who want either a holistic solution and or institutions that may not have the resources in-house to plan all of the shipping, or on the storage side, they don't have either capacity on site or in their existing storage, offsite storage. It's helpful for them to plan and get a sense of cost. So for example, if you had
excess empty crates post, for works that are on loan. Where do those go? What are the temperature requirements of the institution? Often institutions will accept temperature only storage, so where it's not humidity controlled for empty crates. Some institutions will accept non-climate, or in the Northeast, we term that heated. If it ever gets cold again, we would turn on the heat, but for now, it's just non-climate. And then sometimes there's a requirement that's shared with us for fully climatized storage. There are cost implications there that might go into the planning. For a traveling exhibition, is it contiguous, or maybe there's a stopover somewhere? There was a Miami-based museum that we were working with, and they were going, the next time the show was being put on, it was going to the Desert West. And ultimately, they decided to store with us in Dallas because we were able to offer a quality and cost-effective solution there. So the more that we're able to partner, the better, but the time frame, I think, in our instance, is better when the need has been identified.
Well, that makes a lot of sense. This question is really for all of you. Do you find that the standard of care, and talking about sort of the negotiation, when we all get involved in negotiating the loan terms, do you find that the loan terms and the expectations of the lenders are different when it's for exhibition purposes than it is for commercial situation of consignment at auction or consignment to gallery for sale? Do you think that there is a different standard of care? And if so, why?
I don't think there's a different standard of care that we exercise, but there's a possibility people think about it a little more in a negotiation, just because when you're selling, your expectation is it's going to sell as quickly as possible. So you have an expectation that this organization knows how to handle art, and which we do. And so you're focused on other considerations, right? But if you know you're going to be a part of an exhibition that might last for 6 months or a year even, that's a different consideration, because you're not thinking this is going to sell as quickly as possible. You are going through the seasons. You are thinking about what else is happening in that physical space during that time. Are you going to be moving my work a lot? Is it going to travel? So it's not a difference in our standard of care, but it may be a difference in their focus on it and just saying, let me understand a little more about what's happening.
Makes a lot of sense. Do you see any difference in shipping or insurance and requests?
From the insurance side, I really don't. I think, sorry, Tanya, but when collectors are lending to galleries, I think they might be a bit pushier in what they want to achieve, whereas with the museum, I think they might be lending for different reasons, really philanthropically, culturally, so they may bend a little bit quicker, but generally the insurance standards are pretty much the same.
Yeah, I would say that, we offer sort of a menu with standardized levels of care, temperature being one where there are variations that clients can choose from. Some galleries do accept temperature-only storage, more than museums, I would say, but otherwise, you're trying to provide a consistent level of service.
And so what key points do you see collectors bring up to you in terms of negotiating the loan agreements or the loan of the artwork to your institution that has been coming up recently?
Right. One of the things that we see a lot, and it's an interesting negotiation, and that's when we would get involved, is this is the Met Standard Loan Agreement. It's great, it's concise, it's only 2.5 pages, and we encourage you all to sign it. A lot of people have their own paperwork, which is also fine. And one of the provisions that can be tricky for us to negotiate is what we call absolute liability. It's sort of building off of what Kirsten was talking about, which is to say that when the work of art is in the collector's home or in another museum's galleries, there are certain standard fine arts exclusions that would apply. Sometimes when lenders loan to the Met or other institutions, they want to hold the Met or the borrowing institution to a higher standard. And they basically say any damage at all whatsoever, even if it's excluded, we want you, the Met, to be responsible for that. And that is not something that we want to agree to in all cases, if I'm being honest, because, or really in any case, we look to fine arts insurance to allow us to do the kind of incredible exhibitions that we do, together with the U.S. government indemnity program when it's applicable. And we can't really be held responsible for damage or loss that's outside of those coverages that are provided. That's just an unknown liability, and it's not something that the collector has when it's on their own walls. And so we try to make those kind of arguments. When we're making those cases, we talk a lot about what things are excluded, and you mentioned broad coverage. I think that's a point we often make. We have very broad coverage. We have great fine arts insurance companies. We find that the fine arts insurers are really responsible and respectful of the process. And we hope that people will agree to limit the museum's liability to what the fine arts insurance pays out. I would say one anecdote that I'll share is we had a few years ago, we had a lender who said, if there's any loss or damage, I would like the full value of the loan. And I said, that can't possibly be what I was speaking with a lawyer. So I said, I can't imagine that your client would think that like if his fender was broken on his car, that he would get a new car. And he said, oh yeah, you're right, let me go talk to him. He called me the next day and he said, no, it turns out he wants, if there's a scratch, he wants the full loan value. And we talked with the curator and we said, that's really not something that we want the museum to be responsible for. And ultimately, the loan was not part of the exhibition as a result. So that's where we try to have those negotiations and then make the tough decisions if we have to.
You already answered my question, which was, when that happens, do you reject the work? Yes, you do.
I would just like to make this point. It's always very difficult for me to decide whether or not I'm going to participate in these panels, even in the planning process, because I'm often negotiating against Ann Laura. So I'm like, no, I can't think of anything that other clients ask for that you have not asked for yet. And so, and I mean that sincerely. But one of the things with respect to insurance, and a point that was made earlier, which is, we think it's a fair position that you be in no worse position than you are when it is hanging in your home. And it might sound like, oh, I'm just trying to protect the gallery's interests. But this is an auction house consideration as well, which is insurers insuring in this market are taking on huge concentrations of risk. And so it's important for the entire market to make sure that insurers still want to be in this space, right? Because you have low probability of loss, but you could have catastrophic losses at any of our institutions or with any of our clients. And the more and more aggressive you are when you're negotiating with organizations, and if they're desperately, and they don't feel like they can say no because it's so important to telling the story or so important for that sale, and they start going outside those lines and saying, we will take on that commercial risk, the insurers don't like it, right? Because they have these block policies and global policies with major institutions, and they expect when you tell them that this is how you manage risk, that you are following those rules. So the more you step outside of that and say, I will take on that commercial risk, it concerns the insurers, are you the right parties that we should be insuring? So I would just like to make the point that it doesn't help the market as a whole when we are being, I'm going to be judicious with the words I use, just aggressive in negotiating, because it might seem like, oh, I'm protecting my client so much, but there is a balance, and we're sort of all in this together. And as I often tell people, especially with our consigners and alike, this is a marriage. This report, I know we were talking about prenups earlier, but consignment agreements are really like marriage contracts. I'm signing on to be your agent. I don't want this to be adversarial. I want it to be fair to your interest as well as to mine, because I have an institution. My first client is Gagosian, right? And then there are our clients. I have to often convince my colleagues of that as well. But it's important for us to think about that as a market when we're negotiating with one another about these things.
I'll even just add that in the whole negotiation process, it's important to bear in mind that there are really two contracts at hand. There's the contract between the borrower and the lender, and then there's also the contract between the borrower and their insurance company. And it's really important that the borrower and the lender are not agreeing to terms that the insurance company is not going to agree to. So that's really where the broker comes into play. Full liability is not negotiable, sorry. But
I've heard this before.
But there are other unique requests that can be talked about. They're going to come at a cost, but If it's not any loss is a total loss, maybe it's any loss above 50% is a total loss. Or in the event of a partial loss, a collector really wants XYZ appraiser to be the one determining the depreciation value and XYZ being the one completing the restoration work. Those are terms that generally can be negotiated with the underwriter, but it does have to go that extra length. It cannot just be in the one loan contract.
And let me ask you a follow-up question about that partial loss, that 50%. Is there, I imagine that the premium is a lot more expensive, especially when we're talking about really high-value artworks for those types of exhibition. You know, I'm not asking you for a quote on like right now, but can it be cost prohibitive, especially when you're really getting really close? Because I imagine those are coming very close to the exhibition, and so you may not have the time to be, you know, have the competitive quotes that you were hoping to be able to give earlier on. But how does that impact sort of the exhibition and the potential to have the work in the exhibition?
Thinking about the possibility of damage and,
yes,
and how the claim.
Lowering that partial loss or creating a partial loss concept in
Yeah.
those insurance policies.
It's it definitely elongates the process, and it has to be a special underwriter that wants to consider that and agree. And we talk about really the security, who's shipping it, what is the possibility of damage from occurring. Partial loss is the number one claim that we see. We generally don't see total losses. So ideally, that is not agreed into the contract. It's just if there's partial loss, it'll be paid the standard, which is the cost of restoration, and then the cost of, and whatever the percentage depreciation is as well. I think underwriters are willing to bend if it is critical that this work is in the show, and that is what the lender is demanding.
And Laura, I'd just add, first of all, I wholeheartedly co-sign what Amy and Tanya said about the importance of the insurance community for us to operate. At WOVO, we have a lease for those clients who have storage, and then a master services agreement that a client engages with. So we're not contemplating the value of the objects in the services that we're providing. It can be, you know, for hanging the kids' artwork on the wall, or being, you know, entrusted with a $100 million masterwork. So that agreement has to protect us in all instances, because it's unrealistic to say, you know, we'll accept $15,000 for a services project and be held to the liability of untold millions, which aren't even being communicated to us because we don't require any sort of appraisal in order to handle. So, you know, we really rely on our insurance partners, our clients' insurance partners in this instance, to make this all make sense as an industry. So just pointing that out as well, that the ecosystem is so important.
And since Tanya mentioned it, I don't want to, I know she feels like I may use some of those points to negotiate, so I am going to ask Alexandra and Tristan, what would you recommend for borrowers to think about as they're going into those loans from an insurance and logistical standpoint, sort of the key elements that they should be looking for in those loan agreements, that they should be asking about, and making sure they feel comfortable with sending the works to that exhibition?
Yeah, I mean, I think if you're going to put them in buckets, you're thinking about the environmental considerations, the team, and who will actually be handling, and security. So, you know, if we look into those from an environmental standpoint, every fine art service provider should be able to give you a facility report. What is, you know, the heating, cooling, humidification systems, or dehumidification, depending on the environment. Is there a redundant system? What is the maintenance protocol for that? How often are they being replaced? Is there a facilities person? Ooh, mics, okay. I love a handheld mic. This is exciting. It's like karaoke. Anyway, yeah, you know, the general ethos at WOVO is we own our facilities. There are certain instances where in an M&A deal we have assumed a lease, but you know, with the owner's mentality, when was the roof replaced? What standards are you keeping the building up to?
Is it in a earthquake prone zone, a flood zone, hurricane proof? What is, the different factors that come to mind when you're really thinking about the building itself? I think that's a very important thing to consider and to compare across the industry. Security, similarly, what kind of system are they using? Digital. A lot of people ask me, is there a security guard? In our instance, no. Those people can be compromised. It can be dangerous. The insurance community has really dictated that a sophisticated digital system is preferred. But again, it's not standardized across the industry, so it's just worth looking into and considering what works best for you. Is it a mixed use building? What's the access look like? Are there windows? What alarms are there? How close you are to a fire or to a police station are all things that you want to have, again, considered or reported to you as you're making that decision. I think from the handler perspective, it's really what does training look like and what are the security protocols. And from the training perspective, we do first just the safety, how to lift, what PPE might be appropriate for a specific job. Then thinking about hardware training, what tools are your teams given? Do they know the specific types of hooks that are best suited for specific artworks? How do you measure it? How do you assess the site? What type of wall is it? Is it weight bearing? Do you have to think about an outdoor sculpture and what concerns could be present based on different considerations of the actual artwork? And then, what is the experience of the team? We do a mentor program, and I think that's somewhat common. The more experience, the more you see, the more you can impart that upon a handler who maybe is newer to technical operations within the art world. And then, what kind of inventory control measures are available? Are there digital barcodes that are somehow tracked to some system? Are they tracked and signed into the truck? Can you, track that truck? What are the route routes? Is there a camera inside the cab? And again, I think if I was getting a takeaway, because I know I'm sort of embodying a facility report here, but just really thinking through, what are your concerns? Are your concerns that they're driving through Times Square? Then, get the route. Do you want security to detail, to follow the truck? Is there a limit for how much can be on the truck? This is all things that we will work with our clients to ensure that we're meeting whatever the contractual obligations are and/or the specific concerns of the client.
So the next time that I have an artwork where I'm actually concerned that it's Thomas Crown Affair type situation, I will call you.
I love showing up at work and having, a black car there with someone who's clearly security. That's a highlight. So everybody does it their own way. Yeah.
Kirsten, you were going to say something.
No, sure. Just from our perspective, we generally are always recommending our clients are using a dedicated fine art packer shipper. As I mentioned, transits are the #1 cause of loss, so it behooves the client, if they're trying to protect the work and prevent damage, that they're working with a professional that has vehicles with climate controls, GPS, air ride. They're using dual drivers. They've got background checks. They're trained specifically to handle fine art property. That said, I will say, and for the insurance professionals in the room, I'm sorry, but there really is not any exclusionary wording on the policy that you cannot ship via FedEx or whatever it may be. So there is some leeway as a broker, as a risk advisor. The WOVAs of the world are really the way we want to go. And thinking in terms of exhibition as well, I think a big question that I always ask is a work going directly to the institution or to the gallery, or is it temporarily going to go to a warehouse for logistics reasons stopover? And if it is the client comfortable with it? Let's talk about the facility report. Is it going to a facility in a flood zone in the middle of hurricane season? Does the borrower purchase terrorism coverage at this warehouse? terrorism is is a big topic in our world. We find that sometimes an institution or a gallery might not purchase terrorism outside of their main gallery museum locations because warehouses are a little off the beaten path. But we don't want our client to be in a worse position, so that's a question we would ask. And then double checking the exclusions. If there's a mysterious disappearance exclusion and it's going to a warehouse, that would probably be a little bit of a concern that I want to ensure that can be removed.
And moving away from the insurance and our insurance partners, Amy, can you talk a little bit about the indemnity program and how this works at the museum level and how you use them for some of the amazing exhibitions you put together?
Sure. So that, is this on? You can use mine. Oh, okay. Hello. The decision that the museum makes about whether to apply for U.S. government indemnity to cover an exhibition is really managed and driven by the registrar's office together with our deputy director for exhibitions. And so for certainly international shows, like the Michelangelo show, or I think the Siena show that's there right now, we would apply in the cycle. It's a pretty, it's a process wherein we get third-party appraisals of all the lender values. We make decisions about which works are going to be on and off the list because U.S. government indemnity has certain things that they won't cover, certain oversized panel paintings, or they take a position about pastel and chalk that we don't always agree with. So, it's a very complicated application process. And then when the government indemnity is granted, there are often, sort of extra requirements around the number of transits and the security, and maybe it's the posts of guards versus also the combination of electronic and other devices that we use to sort of as an extra layer of security. So it really is a rigorous process, and we really like it when our lenders agree to accept U.S. government indemnity coverage. It allows us, the flexibility to maybe have more works because we might be covering those on our under our fine arts insurance. And really, I think it's also really well regarded with international museums. So it really does facilitate the exchange of cultural works of art in the way that it was intended to be when it was founded, I think.
How often do people push back on the government indemnity and want to have the Met take this on their private insurance rather than the government indemnity program? Do you feel like there's a lot of pushback?
I think there can be pushback in sort of a couple of ways. One is that I would say we have greater certainty around how our fine arts broker and underwriters approach the museum clause in fine arts insurance. Then I'd say there's greater certainty in insurance than under government indemnity in terms of if you're borrowing from a country where there's like an ownership, France, they can't deaccession works of art. So if something comes over and it's basically declared a total loss, they still get, the remnants of whatever was declared a total loss. That's one area where there can be uncertainty. And then also I think some private collectors just they think they don't want to have to deal with the government. And that's a hard, I don't have a good argument, actually. Shouldn't have admitted that. I'm not the one making the argument. But, you want the lender to be comfortable. And we really do try to reassure them all the questions you guys are talking about around the facility report, the security. We have extra, we have motion detection that can tell people they're too close to the art. We use AI so that we can see if somebody's raising their arm and maybe gonna throw tomato soup on a work of art. So we have a lot of great protections that we can reassure lenders about. How the government is going to approach, in the event of loss is not something that we have the same control over. So in those cases, we would cover it under our insurance if the loan is important, which they always are.
Well, thank you very much. So I wanted to talk about certain topics of when things get a little bit complicated in the loan world. Not that it has not been complicated thus far. But I wanted to ask in particular, Amy and Tanya, how they deal with situations where artwork are being used as collateral for existing loan agreements for the lenders. It's often the case, and that brings a new player into the mix. So I wanted to give you both the opportunity to talk about how you deal with this and what are the takeaways or things that you would like to share.
It's an interesting consideration because often when people talk about wanting to be in this field and wanting advice on how to become an art lawyer, I often say to them, the best experience I had at Cravath was doing secured transactions, right? Because I'm very comfortable with understanding what's happening here, what the bank needs. And so when I find out there is a lien on this from a bank, I'm not particularly worried about the negotiation because I understand what they need to get to in order to protect their interest. And so you want to know that as soon as possible. I've had instances in my career where people will sign an agreement and write a little note, B of A, and you're like, what is that? You know, and so let us know early, and have a conversation. There's not a lot of players in the market that use art as collateral. And as a result, they're used to their collectors doing things with the art, whether it's lending it or getting ready to sell it. So you're not in a situation where a lender is like, who are you and why would you have possession of this art? It's our collateral, it shouldn't move. So you have, the players know one another, but you want to know as early as possible. You want to make sure you're not dealing with having satisfied the lender and then suddenly the bank has different considerations or different requirements. And the bank has to have time to make sure that they're comfortable that their interests are being protected. And depending on where that bank is located, how they have to make sure that they feel like their security interest remains protected as best as possible. So as early as possible, knowing that it's going to be a part of the negotiation, and it's not unusual, right? Now, what's interesting is you will have, I think the more difficult point for me is sometimes my colleagues are not accustomed to it, right? Our stars, our divas. And so, you know, let's not complicate everything. It's not complicated. We understand there are adults on the other side of this. We're experienced with this. We can make this happen. And so I think that's where you get the greatest friction, is that the people who are the closest to the art and the salespeople are not familiar with dealing with banks and art as collateral. So they get scared. But the lawyers, I don't think, are scared by it at all.
I agree. I think for us, I think it's helpful to know as early as possible if there is going to be additional paperwork associated with a loan. Some of the area, and we definitely want to make it such that like the loan agreement is going to govern and the bank is going to accept the insurance coverage that we're providing. We don't want there to be extra obligations that come from the role that the bank is playing. I think for us as well, we always want to be able to release it, if possible, release it to the lender or the next venue without having to take an extra step of telling the bank. So those are just some of the things that we try to think about. And yeah, I think knowing early on can be helpful. Sometimes they come in kind of at the end and then you're in a negotiation with the bank. And I remember one instance where the bank, they had a provision that basically if the owner defaulted, they could like withdraw the work immediately. And I said, would you ask that you would, you know, allow us to continue to put it, to allow it to stay through the end of the exhibition, because we've invested this money, there's a spot on the wall, there's a label, you know, our handlers can't go in and take something off the wall, you know, at the drop of a hat, and they refused to budge on it. And so we sort of had to, you know, cross our fingers and hold our breath and hope that everything would work out such that the loan would stay through the end of the exhibition. So I think, you know, we want to, you know, respect the lender and the bank and all that, but we also don't want extra obligations on ourselves, I'd say.
And that's a very interesting point. I think it was easier for me to negotiate this point when I was at an auction house, because I would say, listen, the point of you exercising your rights as a secured party when your borrower has defaulted is so that you can get the money, the value for the collateral. So why would it make sense after this thing has been published in a catalog and we have spent so much money as an auction house publicizing it, would you pull it now? And hopefully you have a smart person on the other side. I've had some instances where people think, no, I want it back. I'm like, but why do you want it back? Because you want the money. So why would you take it now? I don't like using the burn word, but you know, every once in a while you'll say, look, you're burning it. You know, the market is not going to necessarily know why you pulled it. Allow it to stay with us and let's negotiate what happens with the proceeds. That's what you're most concerned with. It's a little different when you're dealing with a gallery and this is something that may not have gone on the wall but may have just come in on consignment. And so then you start having a conversation on where you are in the process of the consignment. If I already have an interested buyer, Again, I want to be careful about how much I talk about this. Okay. If I already have an interested buyer, we have invoiced, we're already talking about when payment is coming in, it does not make sense for you to pull this back and think about how to get value at a later date. And so the negotiation is a little more nuanced in the private world than in the auction world, where it makes all the sense in the world to let it stay the course, go through the auction, so you can get the value.
Do you have lenders who are more concerned about, or banks more concerned about the fact that it's on exhibition, so it's more likely or susceptible to damage, and it's on the facility?
Can I respond to that first? I would say that when it's on exhibition at the Met, it's less likely to have damage. You know, we have professionals, we are in the business of protecting and safeguarding our own collection, and our standard of care for the loans is the same as what we would take with our objects. So I think we feel like it's, you know, for a bank in particular, it might even be, dare I say, better off on our walls and on display for all the reasons that we're talking about. Now it's in the catalog, now it's gotten, you know, greater acclaim because it was part of the Michelangelo show, let's say. So that's how we would view it.
I think that's a fair point, because it's sometimes surprising how people store their collections, very valuable collections, right? And so it is often better off in the hands of organizations who that's all they do, and they care very much, because our livelihood is based on how well we manage those works.
I am not going to say I've had clients who have confessed to me having no insurance on Masterworks. So talking about the termination, Amy, that you just discussed about sort of that risk profile that we have sometimes in loan agreements and lenders of work who wish to terminate the agreement for various reasons. Do you see this happen, and in what context, and how do you address this request for terminating the loan and getting the work back before the exhibition ends?
It's a good question. I think I would say it doesn't happen often with us. I think, again, we start with the relationship between the curator and the lender. Often that's a good relationship, and the curator is able to use their powers of persuasion to encourage the lender to leave a work through the run of the exhibition at the Met. And I'm often, you know, happily surprised that lenders will be happy to, you know, not just have it go to the Met, but then go on to 2 or 3 other venues without pulling them. So I think we get the benefit of the relationships that the curators have. At the end of the day, if somebody, you know, insists on pulling a work of art, you know, we have to sort of take it case by case. I can think of a handful of examples where, you know, it was a longer term loan, and a lender, you know, kind of took issue with something that the museum had done, and so pulled it. And in that case, you know, if the relationship can't help you keep the loan on the walls, you know, we don't own it. So we're going to pack it up carefully and send it back.
What about you, Tanya?
I'd have to say, you know, I can't think of an instance where it's happened in my experience where someone needed to pull something. I think people decide if they're comfortable at the beginning of the process, right? I would imagine if we had to deal with that, and I even thought about this as we were thinking about the panel. I haven't had those instances. I think the likelihood it would happen if it were something outside of the person's control, because when you're lending something, you know exactly how long the exhibition is. And one of the considerations as well for us is that I would make the distinction between exhibitions where we're dealing with collectors and we're just putting on an exhibition because we think it's just an important story to tell at that particular time, like our fabulous Picasso exhibition, versus exhibitions that we're doing with an artist and it's just the artist's exhibition, right? And so they're 2 different buckets of considerations that we have. Obviously, we're not going to have that with an artist unless something were damaged, and I don't know if there's any wood around. And then with collectors, as I said, I would imagine it would have to be something catastrophic happening in their lives because they've made the commitment. If someone felt uncomfortable with the length of the commitment or what we needed to have happen in the exhibition, it's more likely that they would not participate versus wanting to pull it.
And Amy, a follow-up question: when you have exhibitions, and have you ever had this situation, and I'm sure you have, of the work changing hands and the exhibition being used as a venue to sell the work, and how do you address those? And do you take the works off the wall? Do you take do you return the work to the owner? How do you handle those types of relationships?
I'd say that it's a standard provision in our great little loan agreement that we ask the lender to agree not to offer for sale or sell the work of art during the term of the loan. I think it's still pretty rare, but it's slightly more often that it would happen, that it might change hands before the exhibition opens. And so then it's like, oh, we didn't know the owner was going to offer it for sale, or maybe, something happened in their life and it was a change of circumstances and it needed to be sold. And in that case, it becomes, again, the persuasiveness of the curator to try to persuade the new owner of the benefit of signing our loan agreement and allowing the work to continue in the exhibition. So I think we much prefer that things just come and remain on view. We are a not-for-profit, we're an educational institution, and we don't want to be treated like like more commercial. And so that's something that sorry. But yes, it can happen. And when it happens, we try to, keep the work on the wall. We try to, maybe we'd have to change a label, but it's pretty infrequent. And I think we're grateful for that.
And Tanya, I wanted to ask you how you deal with, going back to the bank and lenders and the concerns over financial stability, and maybe sometimes the request to file UCCs against the gallery. And it's not limited to the Bailey-Baylor relationship in an exhibition agreement. I imagine it's also for consignments. But how do you handle those? Do you have any concerns? Do you have any requests when those types of clauses are added to the contract?
No, I'm not particularly concerned. I think what I'm most concerned about is if it's actually sold and you're paid, that you make sure you release it, right? So we routinely look at what UCC filings are outstanding against the gallery. If we can push hard, sometimes in different organizations I've been a part of, you'll sometimes negotiate, can I file a UCC termination? Because we know that you have been paid. And one of the things I would say whenever I'm dealing with new lawyers in the field, I always remind them that you want to release the security interest as a matter of contract law and not at the time of the UCC filing. So be very careful about how you're drafting. So I say in a contract, it's released upon your receipt of the proceeds. And you'll record that release by filing that UCC-3. But it's not released upon the filing of the UCC-3, and you're not agreeing in the future to release your security interest. We're agreeing now when A and B happens, that security has been released. So I'm less concerned with the UCC-3s as I am with how clear we are about the automatic release of those security interests once we've paid you. And I will see agreements where people agree that the bank will agree to release their lien. No. When I give you the money, it's already baked into the agreement that your lien is released. And we can fight and haggle over the filing of the UCC-3, but I know as a matter of agreement that that lien is now gone.
And I'm going to give everyone the very exciting CLE code, which is Exhibitions 85 and X, capital letter. I will say it one more time, Exhibitions 85X. Amy, Tanya, Kirsten, and Amy, any specific issues to be mindful of when you have works that are coming from outside of the United States and into your exhibitions here?
I mentioned when I was speaking earlier, I touched on the immunity from judicial seizure, which is the federal statute that protects foreign-owned works of art that are coming in for temporary display in the US. And so I think that's something that we routinely apply for all foreign loans. And it involves, sending an application to the State Department, and then they make determinations that the works are, here pursuant to a loan agreement, they'll be here for temporary display, and that they're of cultural significance, and then they publish a notice in the Federal Register. And then those works should be protected in the event somebody comes along and says, I sold that work of art and the person never paid me. In theory, you go to federal court with your Federal Register notice and you tell the judge, like, if this is an issue, it's between these two parties and we, the museum, should not have to play a role. We had a recent case with the Detroit Institute of the Arts, I think it was last year, where there was a dispute about ownership of a work of art, and it did get a little bit more litigated than I think we would have expected. So there, but in essence, that's something that we would, that we as a borrower would do, both to protect the lenders of foreign works and also the institution.
Thank you. Thanks. I think for incoming loans internationally, the number one thing that we're concerned about is the shipment, and critically making sure that a condition report is completed prior to that work coming in. I unfortunately have seen too many claims where a condition report was not completed prior to a shipment, and we have a situation like this where we have no idea when the damage occurred. Was it in shipment? Was it when the work was sitting in storage for many years? And it makes the claims process very challenging. So specifically for international loans, that would be a big consideration for me. But forgive me, and Laura, I'm going to flip your question and actually talk about
Please do.
Loans going abroad.
I was going to ask the follow-up question, so you got it.
Because that's more of a larger concern for me. I find the standard of insurance for international borrowers is not as up to snuff as our domestic carriers. So that's when we really want to put our glasses on and read through the contract to understand what is excluded. And even beyond that, what are the terms of the coverage that are added in. I've seen many, many times it's not excluded, but there's a condition that if an item is not suitably packed, it will not be insured. Which is very vague, and I don't like that. So really reading between the lines, other exclusions, theft from a vehicle, employee theft. If a work's going to a museum and it was the gift shop representative that intentionally damaged an artwork, is that going to be excluded? We think a lot about the climate protests that you mentioned earlier, Anne-Laure. So is the collector okay with glazing the artwork if they really want to proceed with a loan to protect the work from any possible paint spillage? Thinking through these international loans, then we really have to drill in and talk about options. So option one, proceed as is and hope for the best. Option two, see how the borrower is in negotiating the terms to get them exactly where the client needs them to be. Option three is take out separate coverage and perhaps have the borrower pay for the separate coverage so that the client is very comfortable and confident in the quality of that insurance that's procured. We have the option for the lender to insure under their own policy, which we generally don't recommend because it's out of their control. They can't insure who's going to have access to it or what the security is, and any loss that's paid under their policy will affect their loss history. And then the final option, which we always try to avoid, is maybe the lender decides that they just don't feel comfortable proceeding with that. At the end of the day, our job is never ever to get in the way of a client completing the transaction. We're always trying to find a path to yes.
Just to quickly add on that, and I can circle back to the condition reports. We have different levels, condition checks, condition reports. We actually worked on a proprietary software that standardizes what that output looks like, which I think is really helpful to the end user because they know what to expect. If an object has been subject to a condition report twice by WOVO, you'll be getting a very similar product and better able to assess whether something has occurred. And then about thinking through sending abroad, one thing you might want to consider is whether your fine arts services provider has a TSA screening certification. And if the designated screening can occur at the facility, that's ideal. You have trained art handlers who will then be doing it rather than any sort of potential of opening, at the airport with less trained hands. So the more that you can do with the proper professionals, the better the outcome.
And obviously, we've never been in a time crunch in our life. Those never happen. We are always brought in way ahead of the exhibition. But in this unlikely event, there's a time crunch on a loan or an exhibition. what can you do from a logistical standpoint? What are the limits that you can do? What's the impact of that shortened time?
I was thinking about this, and I really ultimately landed on the only hindrance to an unlimited budget is the imagination. And the space-time continuum, I guess. So, if it's, well, that's exactly it. But yeah, to the extent that there's the means to facilitate the solution, we can be quite responsive. But, to Tanya's point, there's usually some budgetary concerns. And so we're looking at, what an exclusive truck might look like, this is kind of outside of this scope, but there are clients who will retain us for emergency planning where they have the ability by paying an annual retainer to, bump people off the schedule. There's a premium that comes with that because we don't want to have the affect of other clients, this like hurricane plans and such. But yeah, it's again, with the budget, you can pretty much get anything done. Spoken like a service provider, but yeah.
And Gersten, from an insurance standpoint, do you have any limits, or is the sky the limit?
A good analogy is that you can't buy insurance for a house that's already on fire. So if the transit's already left, I'm sorry, I'm probably not going to be able to increase that transit if it's gone. But it's really frantically calling our underwriters and having them on speed dial, because I can't make that decision. It's the underwriters that have to sign off on it. Knock wood. Generally, we work well and are used to being under pressure. But the impact is normally financial because we just don't have the time to give as many options as we typically like.
Can I ask a question? How do underwriters feel about these sort of last minute requests?
Are there any underwriters in the room that I see Tim from Berkeley? Yeah.
You are not alone.
No. Yeah. I think underwriters, same as brokers, understand we operate in the art world, which is very fast paced. So while they might be frustrated, they got to just get the job done.
And then I'm going to ask the question that probably none of you wants to answer, which is there anything that a lender has asked for or required that is a big no-no for you that you just won't agree to?
Sure. And bottom line is insurance doesn't cover everything. I can't get insurance coverage for nuclear hazard, even wear and tear, gradual deterioration. There are some things that just cannot be insured. Otherwise, we try to avoid saying no.
Yeah, just quickly to follow up on that. I mean, we can do a waiver of method if somebody really wants to do something outside of what we would recommend. Not ideal. Otherwise, I mean, our red line is taking on liability just because it doesn't make sense for the business.
I think, sorry.
Hazardous materials being a big no-no too. You can't risk other people's artworks for one, if it's organic or otherwise.
In terms of lender requirements that are a no-go for us, I mentioned the one sort of any loss or damage. I think another one that can pose a challenge is we talked about 50% or more being declared a total loss. There are certain types of requirements like that where we just don't feel comfortable asking our insurance company to cover that. We don't think it's we're just not comfortable. So in that case, it might be that you maintain the lender's insurance or some find another way to get to yes. But there are certain things that lenders require that we just we can't accept. And we really try to persuade them and encourage them and explain to them that no, our employees are not going to sell it off the wall, and no, it's not, but we, sometimes lenders just aren't comfortable lending as well. So that's kind of where we land.
And I'm going to ask a similar question, but hopefully in a positive manner this time, which is, what would be your top 3 choices, top 3 recommendations, wish list, dream list in connection with loans and exhibition, if you had a possibility to write those down and make sure that they get done in connection with the exhibition, what would those be?
You should have told us that before today's panel. Wow. I think, ideally, I think it's more of an internal consideration, right? Which is that I have the time to go and speak to the person who's going to be the head of that exhibition. And I have a sense of how many lenders are we going to have? Is this going to be a handful of people, or is there an avalanche about to hit me, right? How much time and planning has to happen? Do I have an opportunity to coordinate with press and publications to really understand any particular concerns? Because you can have some clients who want to be very private, right? Some works, everyone knows who owns it, right? And others, they're like, I don't want my name associated in any way. I may or may not want it to be sort of in the forefront of how you publicize the exhibition. I might have an opportunity to, let me think of something else. I'm so rarely thinking about ideal situations, so this is a little, it's a little hard. I think it would probably be more, I have the opportunity internally to connect with all of my colleagues, and I'm not being reactive.
I also spent time at Sotheby's where I liked valuable art. I now, in my role at Wovo, love empty crates. So that's my ideal circumstance. But I think, you know, in an ideal sense, somebody who values the service and understands the expertise and provides clear instructions and a time frame really allows us to operate most optimally.
I'd say you work with a broker that you trust, that is working for you and not working for the insurance company. And to broaden that, work with all professionals that you trust, your legal counsel, your appraiser, your art advisor. Use a dedicated fine art packer shipper, and please complete condition reports.
I think if I'm coming back to where I started, which is I think in our ideal world, a lender would sign our standard loan agreement and not have, and accept our insurance and agree to limit our liability to what the insurance company might pay out. Not ask us to indemnify them for any claims or taxes or other things that they might know much more about because they're the owner and we're just the borrower. So those are, from the counsel's office perspective, I think the ideal circumstance for an exhibition.
Great. So I think that concludes the panel. We're perfectly on time. Thank you, everyone, for being here today. And to our panelists, thank you.
Okay, well, I think we're going to get going. I'll actually talk a little bit, maybe eat up a few minutes so we can get more of a critical mass in here. I just want to remind everybody, especially those that are virtual, to please document the CLE code that comes up in the middle of the session. It's usually about 45 minutes in. I also want to remind everybody, please take a goodie bag before you leave. As well as if you are an attorney and you are in person and want CLE credits and haven't already, please go back outside and sign back in. It's key, and you're probably used to this whole routine. Our Let's see, I think that's about all for housekeeping. Oh, good, someone's going to run out. Okay, we want to make sure you get those credits. For those that are members of the association, you will automatically get a CE credits, and you just need to go online to download your certificate. Okay, well, I hope you enjoyed this morning. Our afternoon panels start off with Hot Topics in Art Law, which is going to be moderated by Bill Sharon, partner, co-chair of Pryor Cashman's Art Law Group. Bill founded and co-chairs Pryor Cashman's Art Law Group. He is also a member of the firm's litigation, intellectual property, and media and entertainment groups. Bill specializes in art-related litigation. He has received a Band 1 ranking in the Chamber's High Net Worth Guide for Art and Cultural Heritage Law, and was named New York Law Journal Trailblazer for founding the Court of Arbitration for Art. You can find more about Bill in your materials, as well as the rest of the panelists throughout the day. They've been included with your program. Okay, Bill, I'm going to turn the panel over to you.
Thanks, Linda. Thank you very much. I apologize for my voice, a little bit of a cold, but I think it'll be able to muscle through this. We have a great panel today. Unlike the morning panels, which had kind of unifying themes, we've got 3 disparate topics. And I was trying to think of what would be a congealing theme for all 3. And what I thought of was the Warren Zevon song, Lawyers, Guns, and Money. The reason is we've got Greg speaking about fiduciary relationships between dealers and their consignees and artists, and how you structure that, lawyers. We've got Yael speaking about restitution matters, stolen art, artifacts, war, strife, guns. And then we've got Caroline speaking about the role of third-party guarantors in the auction process, the money. With that, we're going to start with Caroline, who is she's been a global executive in the art market for 30 years, currently president and CEO of Cadell & Co. Americas. She leverages her deep expertise in both art and business to support fiduciaries and clients in collecting or selling art. During her previous 25 years at Christie's, she was the first global commercial director launching bespoke financial services, lead-long commercial negotiations, and spearheaded the global expansion of the 20th and 21st century art categories. This included launching the first Western art auctions in mainland China in 2013 and establishing Christie's Private Sales. She is going to be speaking about the rise of third-party investment vehicles and the impact on auction landscape. And with that, Caroline, take it away.
I've already failed. Okay, we're going to start this. Thank you very much for that introduction. This is the grab bag section of today's discussions. When I was asked about a hot topic, particularly around art investment, we probably could spend a good portion of today's discussion around that. There are many areas that we could dive into, but for me in particular, understanding the evolution of the guarantee product in the art market, and in particular the growing outsourcing to third parties, is something from an advisory point of view, is something I think is very important to understand, and understand how it impacts your clients while you're helping them navigate the sale process. Why me? Why am I able to talk about this? As Bill said, my background is in the commercial side of the art market. I was at the forefront of it through the 2000s in building the vehicles, negotiating them, and spent the last decade of my career implementing and executing against third parties. Since I've left Christie's, I'm now in an independent advisory space, but I track closely every season how many house guarantees come out when the catalog comes out, how many move into third parties, and how many are converted up to the day of the sale. And many of you probably noticed, and we're talking mostly at the top end of the market, in the evening sale area, that almost 100% of these sales are being converted or having outsourced third parties. And I thought it was an interesting and hot topic to talk about. So why is it hot right now? Well, because everybody's talking about how the market's slowing down, how we're concerned about sell-through rates, smaller markets, are we going into a recession? And whenever you do that, obviously clients pivot from wanting kind of more profit share structures to seeking out house guarantees. And this is also kind of amplified through the global emergencies, the war in Ukraine, Gaza, Israel, our recent elections this week, and the kind of chaos almost that collectors feel and are trying to interpret when they go to sell. Combine this with the great wealth transfer, which is putting an enormous amount of art onto the market, and it is not necessarily being met with the same level of demand as when it was bought. We're seeing extended life cycles of collectors. So where you used to say, oh, you won't see this for another 20 years, it might be you won't see it for another 40 years. But this mismatch in life cycle is going against this kind of rapid generational taste shift. And so you see lots of articles right now trying to understand, what does the art market follow? How is it? Is it behind real estate? Is it the stock market? And frankly, it really doesn't follow a lot of this. It is individual taste. And the auction houses, and I think Magnus talked about it when we opened earlier, is that you have major selling entities that have big influences in how these markets are run and what's going on with them. So this is what's changed, right? Why is this a hot topic now? Well, one is that we're possibly in a recession, going into a recession, or there's instability in the market. This is the last 12 months. But what's also changed is auction houses have a declining appetite to take on guarantee risk within the house. There is a reduced return against their investments. We're also seeing with the great wealth transfer, extended sale times. I'm sure you've all seen this. You used to be able to go to market within 6 months. I'm seeing sale plan, you'd be in 1 or 2 sales, one sale site. I'm seeing sale plans for large collections that go out 36 months, that are multiple sale sites and sales. And this is all going towards kind of reducing the appetite for auction houses to back those items. And so we've seen an evolution of hybrid financial deals, moving away from this kind of catch-all collection, moving into object guarantees, and it's becoming a murkier space, and it's not such a straightforward market solution. Here's the UBS report. Magnus actually said not to trust this. I think this is okay. Because this is also amplifying kind of what I've just talked about, which is the imbalance of potential sellers and buyers, a general shift within the art market between supply and demand. And these are all components that are raising the risk and lowering the appetite to take on, for selling entities like auction houses to take on this risk themselves. So why don't we talk a little bit about where we've been and what it looks like from a collector's point of view, and the differences between house guarantees and third-party guarantees. This is a very basic outline of kind of the last 25 years and the structuring of financial tools to be able to offset collectors' risk. And in the early 2000s, before the big recession, there were house guarantees, revenue shares. If you don't know, it's a profit share off of the premium. And then we're still doing outright purchases. And this was low risk to your collector and high control. And what I mean by high control is that it was competitive. You had 2 houses or 3 houses going towards you, bidding for you, and it was very appealing to the collector. And they had a lot of control over what they chose, what deal they chose, and what house they wanted to go to. After the Great Recession, guarantees almost were pulled off the table for a very long time. Revenue shares became the forefront product that was put forward. You then started seeing an evolution of hybrid guarantees and revenue shares, and you saw the evolution of third-party guarantors starting to kind of take a bigger role. But you still, during that time period, had auction houses putting their foot forward first and then selling off the risk afterwards. And this would kind of had a medium risk, medium control for the collector. So it wasn't the perfect, but it was still resembling where it had started, and it still had you dealing with one entity. And now since the pandemic, I'm sure many of you have felt this, the house guarantees, unless you're at the very top of the market, are really getting kind of consumed by mega collections and estates. And so you're not getting that kind of offer. You have a lot of revenue shares continuing. They're going straight to market with third-party guarantors, and they're looking at clients' liquidity needs. And this is really creating a much more high-risk space for your collector, because they're not getting that kind of, immediate guarantee fix from the selling entity, and low control, because once you go into the third-party market, which we'll talk about in a second, you're going into the open market, and it is calculating value at a very different rate. So one might say, this was a chart I pulled off, where people will say, well, what's so bad about third-party guarantees? Like here, there's proven information that when you have a third-party guarantee bid and it does better. And this is one of the charts. These are only for items that had estimates, so they don't kind of cover everything. And this chart shows a very favorable kind of trajectory since 2007 up to 2024. And I'll be honest with you, I am not against third-party guarantees. And in some instances, they are really vital, particularly if you're at a very high level value item. If it's a difficult piece, it could be large format, it might be specific. Third-party guarantees, many houses will say, don't go to market unless you have it. But I think the point I'm trying to make today, and we'll go into kind of the differences, is that I see the third-party guarantor model being kind of conflated or equaled to the house guarantee, auction house, and being a very similar product, and they're not, and you need to understand why they aren't. So in the most basic terms, a house guarantee, for those who aren't as familiar with this language, is traditionally was a whole number that was given to a client, that it was encompassing, all parts of your collection. And it encompassed your high risk items as well as your high reward items. You had little to no market exposure traditionally 25 years ago, because these numbers, and it falls into the multi-layered marketing pricing, these numbers were generated with the most sophisticated information that is in the market. I tell people all the time, you will not be able to outsmart auction houses. They have the deepest, broadest, most information about active buying and selling in the market. And so guarantees traditionally were pulled from data, historical bidding, historical sales, and then you have a team of experts who work at this type of the market coming in individually pricing, and they call it a will make. Each house has a different name for it. So it was a very sophisticated process that they go through. You're working with a single entity, you're working with a known quantity, and these entities are been around for hundreds of years. And you have an accountable selling entity that is standing behind that number. And when I mean accountable is that the art market is reliant on a healthy ecosystem, and it is slightly a little bit of a dance, but there are kind of rules that you play by to be able to make sure. And so there's accountability, there's stakeholders, and there's the larger market. And so you have an individual that's not just here for that object, not just here for you, their client, but they're also there in the market. Third-party guarantees are a different vehicle. It is going out to the market. It is finding individuals. It's a bid. So a house guarantee could go up for auction and not sell. Third party will always sell. It will sell at that bid or above. It is not usually collective. It's usually a single object. You do have market exposure, because if you're getting a piece of paper that says, we're giving you a third-party guarantee of X dollar, they have to go to the market to see if they can get that X dollar. So you need to understand that. So there is some market exposure there. You could also be, you're dealing with a personal price versus a more systematic pricing. So they are going out to a third party, and that third party is going to say, this is what I'm willing to pay. So it's a very different way of kind of understanding the value of your object. It could be multiple individuals, and there are some articles under which the third party is selling off their shares. So it can be quite fragmented for a large collection. You could have multiple third parties, and if I'm not a lawyer, but I'm sure everyone's wheels are going, which is if there was a crash in the market, if there were issues, there was a default in payment, you could be dealing with multiple entities backed behind these third-party guarantees. I didn't bring this up on the house guarantee. Also, how these prices are calculated. House guarantees have their premium built into how they're going to make this deal work, and that is depending on where you are. It could be 20% or more. For third party, it's just a discount they get on the purchase. So it's a very different value structure. And then third parties, they're individuals. They have no accountability to the market. They're in it for themselves. They're investors, and they're anonymous. So they don't really have that public kind of viewpoint. And I think these are important things to understand as you are going into this process, and understand that they are not equal or the same. So I covered a couple of these points. What does this mean to you and your client as you're going through it? I think one of the most important things is your pricing, and the shift from the complex pricing strategy to an individual assessment. And so if your client is price sensitive, is looking for that downside protection, a guarantee no longer will be reflecting possibly the better price that they could get. It could be the price that that third party is willing to do. Also be aware that third parties, in an ideal circumstance, they're a private individual who loves the piece and is happy if they buy it, or happy if they don't, and they're in it and they're going to chase it, but they are very rare. Those are not the normal third party. The normal third party really are individuals we already know in the market who are now using this vehicle to benefit from it. So that's galleries, advisors, dealers, investor collectors. There's also organizations, the fractional shares, and more formalized investment vehicles. So it is if your client is price sensitive, it's good to have it, but be warning that it is not necessarily the price of the market if it's a third party. The shift in power, as I showed you in my chart, once you go into the third party market, your piece is competing with whatever else is on the third party market. And so if your client is price sensitive, really being understanding, getting in there early, understanding who they're offering it to, and also, really discussing with your client other options. You no longer sign a single deal, and that's the deal you have the entire time you're selling your property. Third parties are there along through the whole route, for good or for bad, and understanding if your client doesn't like the price they're getting from the third party, they have their own control. It could be, a lot of times it's setting their reserves, giving extended payment terms. There are other levers that they can use to entice the market. We talked about accountability, and that with third parties, it gets a little bit more murky about the accountability, particularly if you're going into a struggling market. Once again, the art market itself, there really is no oversight. There's no regulation. There are limited safety measures, and there's lots of conflict. And that third party does not have to share who they're bidding for, who else they're involved with, and how they're dealing with it. And so be very cautious as you're going into it. Actually, we were talking about this as when I was looking for cases. There isn't a whole lot on the internet. I went through the big recession in 08, 09, where we kind of had our first test of third party and the stability of it in a down market. But it is quite fragile, and often the major auction houses kind of resolve this and are the kind of strong party in between them. But if you're having kind of shifts of hands of auction houses, new ownership, maybe even financial instability, that can move, that could be moving away from it. It could be kind of disappearing, and it could not necessarily be as much of a qualifier as it has been in the past. Now, one might say, Carolyn, you hate third parties. I don't hate third parties. I actually have had an evolution in my mind around them. I had predicted, and I was incorrect, that the market might be, the third-party market might be waning, and they might be stepping away from it. And I've seen no indication of that at all. If anything, I see it growing. And I see it now as a necessary tool within the market to support where we're at. If all third parties pulled out of the market right now, we would be in a very bad position. And they are part of the ecosystem, and they're important. And I'm not saying don't do them, but I am encouraging going in with eyes open and trying to manage it as much as you can. One first would be is active collection strategy and management. I advise everybody, you cannot just come to the market and dump it all into the market and hope that everyone's, that it's all going to be there. It's a very crowded market with a great wealth transfer. The more organized, the more strategic you are, and the more understanding of what you want to achieve and your client wants to achieve from it is vital. It really puts you into the power position versus handing it over and kind of hoping people give you the values, the guarantees, and whatnot that you want. We're not in that market anymore. For risk adverse clients, it used to be you always had to go to auction. It's transparent. It's the way to set the price, particularly for estates. I really encourage alternative sale options, private sale options, or donation options where your client might have a stronger valuation for the piece than they would get at auction. Private sales where you have a little bit more control. It's not necessarily going to get some magical number, but if you have a client that really gets is not able to deal with the lack of kind of understanding or control within the auction market, and you're not getting house guarantees and possibly not a third-party guarantee, I would highly advocate looking at private sales with parameters. If you are going and you get this proposal and they say we have this wonderful third-party guarantee number, understand the strategy for how they're going to get there. Understand who they're going to offer it to. They won't tell you exactly. Limit how many people are out there, and then really understand, does it make sense? So a great example I have is I was given kind of a splat. I came in late. The client had gotten a splashy proposal and had all this kind of finding, and it was very confusing. And it was an enhanced HAM over here, and it was third-party guarantees over here, and private sales over here, and they kind of sliced it up. And I looked through the third parties, and the third parties were being promised to the client for things below $1 million. And when I started talking to them saying, well, who's going to third party that? The money isn't there. Like, there just isn't enough for an investor to be able to be appealing. What does that look like? And it fell apart very quickly. And they said, oh, well, we just put that in there. They're difficult pieces. So I really encourage you to kind of challenge. You don't have to know it all. You don't have to be, no one will know more than the auction houses, but you really need to get in there and say, walk me through this. Where does this make sense? And how does this benefit my client? And understand, because, this is adding, it's like having, what did Princess Diana say? There's a third person in our marriage. It is bringing a third person into your marriage and understanding exactly what role they're playing. And if you do go forward with a third party, be specific and get it in writing, your marketing promises. Because you don't want it to all of a sudden, you've gone to auction, it's already sold, that you're now put to the side and they're focused on everybody who isn't sold. House guarantees did a wonderful thing, and I can tell you because I was the one sweating on the other side, and I know many people in this room behind house guarantees, and you really were laser focused on getting these things sold. Once they're sold, you're not as laser focused, understandably. So really get in writing marketing promises, anything that you believe need to be done to get it sold fast. And then the third part is third-party guarantees are at every point in the sale process. And so you can do it before the sale. They are coming in, I track, we were just, the moment the catalogs come up, I write down exactly how much is house, how much is third party, and I track it to the night of the sale. I don't know if any of you have tuned in, but you probably hear them read about 15 lots in the beginning of the, I now videotape it because it's so fast. But they go up to the moment before the sale. They're frantic, they're hectic, and they can feel very overwhelming to clients and quite upsetting to clients because they feel like, how can I trust these things? And once again, just go through the paces of understanding, will this person bid if they don't have this third-party guarantor? Are they going to chase it? Are they a dealer? Are they private? You know, try to figure out and try to make that best assessment for your client. But you do have to trust the selling entity. They have the best knowledge and they're going to want to sell and do what's best for you. But I think hopefully in this process, you can kind of understand the differences, the risks associated. It is a market necessity, but being an educated individual or consumer for your client around these are incredibly important. And that is I put these kind of 3 items that you can find on the internet. They're kind of recent cases around disputes that have happened with third parties post-sale, but they'll give you a little bit of a view of the complexity around engaging that third party and kind of items that can come up from a lawyer point of view.
Thank you very much, Caroline. We're going to take questions at the end after everybody is gone, so please save your questions for the end. But I'm going to take an advance on the questions, if you don't mind, and maybe personalize it a little bit. I'm just curious as to your role, you know, particularly as you see third-party guarantors maybe getting active and aggressive for their own interests and their own account. What do you do in that situation? Are you kind of a play-by-play announcer and you're just narrating the situation for your client, or are you putting your finger on the scale or trying to massage the deal in some way? And if so, how do you balance the interest of looking out for your client, getting the best deal for your client, but also insulating and protecting yourself from risk?
It's a great question. I think there are a couple ways I look at it. One, when we're looking and we're discussing the strategy of sale with a client, I think we've all seen pieces of art that, you know, auction is merciless. It's not a friendly space. And there are definitely certain pieces that I would advocate under having a hand in the room will help it sell. And I would be proactive in that, understanding what that is, obviously going for a house guarantee first, but also if we're not able to secure that, advocating it, but managing that process. I would say in other ways that I've done it, I worked on a very large estate. If I see a grouping of works, this client had several of a particular artist. It was a $100 million estate, and it was, I think, the 4th of 5 sales from that estate. And from my background, I talked to the auction house about, is there a way to bundle these pieces to a third party where they were able to get kind of in on some of the stronger pieces, but cover some of the weaker pieces. I will also vet what comes through. And so partly it's because I've had this unique space where I've structured so many of these. I was on the execution side that I can kind of say, I can't answer all questions, but these are the things that I'm seeing. And the others are being directive in saying, this might be a good moment to consider this because of the risk or the protection that we think we need.
Great, thank you very much. So that was the money part of the Zevon song. We'll turn to lawyers and Greg Clarick. Greg is a founding partner of Clarick Garon Ricebaum LLP, and he focuses his practice on complex commercial litigation and art, entertainment, and IP law. He's been awarded a Band 1 ranking by Chambers and Partners for art and cultural property law. Greg regularly represents corporate entities and executives, entertainment companies, publishers, visual and recording artists, galleries, and collectors. Before co-founding CGR, Greg was a partner at Manat, Phelps & Phillips, where he was co-chair of the Entertainment Litigation Group. He's a former federal court law clerk and a graduate of NYU, where he served as executive editor of the NYU Law Review. Quite a slouch. Greg's going to talk about fiduciary relationships between dealers and consignees. All yours.
Thanks so much, Bill. And thanks to the Art Appraisers Association for having me here today. I'm just so pleased to be here with these colleagues and this excellent panel. So when I was asked to speak about a hot topic, and we're definitely turning away from the practical toward law, when I was asked to speak about a hot topic, I thought, well, you could talk about where the law is developing. Of course, that's a hot topic. But then I also thought about what is it that's hot in our law firm? And in thinking about what's hot in our law firm, which is a litigation boutique, often working in the art world, what comes up again and again and again and again, so surprisingly, every year, is the question of what are artists' rights vis-a-vis their galleries, and what are galleries' obligations to their artists. We constantly run into disputes with artists and galleries. Usually it's artists and galleries that they had just left, tussling over who has to do what for whom. So I thought that's a hot topic because it seems hot in our lives constantly. And just to kind of set the stage as an example, this week, and there are probably more than one, but the one that's most busy is representing an artist's estate against his gallery. And the gallery is refusing to return works of the artists it holds, some of which it claims to have purchased from the artist. It's resisting our request to account to the estate for sales that it claims to have made and paid to the now deceased artist. So he's not here to help us understand whether those sales happened and whether he was paid. It's unable to locate certain consigned works that we have records of showing consigned to the gallery. And all the while it's claiming that the estate owes it tens of thousands of dollars for funeral expenses it said it paid to the artist's estate as a loan. So I hope that, and I could, talk about where I think these issues will go, but it's sort of the point of the talk is to think about how we think about these issues and how we will be approaching them. I think we all here, the lawyers, are certainly lawyers who've represented artists and have represented galleries, and advisors who've advised artists and advised galleries. I think we all have a good sense of what an artist's rights are and the duties of a gallery to its artists, but somehow too often the galleries seem to lose track and I suppose I would say overstep. So we thought it would be valuable today to start with the basics and just sort of work up to more complicated questions to the extent we have them or people have them. We, of course, in thinking about it, we want to enforce our artist clients' rights, but we also want to ensure that our gallery clients meet their obligations to, truthfully, to protect themselves in the long run. So, wrong way. So, and if there are no questions on that. So here's our agenda. We'll talk about the foundational law. We'll talk about a couple of cases and recent examples in the context of the cases, and then we just will, do a quick overview of what we think we've seen by going through these materials. So here in New York, we start, as many of you probably know, with Section 12.01 of the New York Arts and Cultural Affairs Law. Let's see, foundational law. That's it. Section 12.1 of the New York Arts and Cultural Affairs Law. California has a similar statute. It's in the packet that should be included in your packet from me. But we're going to focus on the New York law today, and mostly the California law follows the New York law. So Section 12.01 of the Arts and Cultural Affairs Law establishes, I really should have started in the beginning of this, whenever an artist delivers, a work, etc., to a gallery, to an art merchant for sale, it establishes a consigner-consignee relationship. And the reason I point out the first three words, whenever an artist delivers a work is because this statute does not apply to collectors who deliver works to galleries. It applies to artists who deliver works to galleries. And we could talk about what that maybe means to collectors. But whenever, an artist delivers a work to a gallery for sale and for payment to the gallery, a consignment relationship is automatically created. And what does that mean? First of all, it means that the consignee, meaning the gallery, will be deemed the agent of the consignor. And actually that might apply also to a collector who delivers a work to a gallery for sale. And the statute goes on, to say that, and this is special to artists clearly, that as a result of this delivery, the property, meaning the art that's delivered, is trust property. And any proceeds from the sale of the works also are trust funds. And this is certainly different from what the obligation or the legal ramification of the delivery of a work from a collector to a gallery would be. Because the trust, as a trustee really of the artist, the gallery has heightened duties to the artists. And certainly, to be sure, as an agent and as a trustee, the gallery owes to the artist fiduciary duties. And in New York, I think we all have a sense of what fiduciary duties are, but in New York, that means, probably in California too, and maybe elsewhere, probably if not everywhere, having fiduciary duties means that the gallery must protect the artist's property and put the artists first. As maybe many of us know, maybe we're here at the Cardozo Law School, so it seems particularly apt to remind ourselves that Justice Cardozo famously said a fiduciary, here the gallery, owes the artist something, and I'll quote, stricter than the morals of the marketplace alone, not honesty alone, but the punctilio of an honor the most sensitive. He said that 100 years ago in the famous case Meinhard v. Salmon. And we all know, I think, that that's a high standard, but just to make sure, I actually looked up punctilio, because truthfully, what is that word? So I looked it up, and punctilio refers to, and I guess I'm probably quoting Merriam-Webster, the most minute detail. So a fiduciary must be honorable to the counterparty to the most minute detail, to the very last detail. And the statute itself, it does two more things that are worth noting. First, it makes the gallery's failure to abide its obligations to the artist not only actionable in a civil case and provides a prevailing artist attorney's fees if the gallery loses a case, which is always a bit of a lever over someone who's done something wrong, but it goes further and it actually makes a violation of the statute a misdemeanor. And it does that by incorporating violations from the trust law for violations of a trustee's duties. So that's serious. And secondly, the statute generally, there's some exceptions, but generally makes its provisions unwaivable. So we go into the relationship between the artist and the gallery, knowing that a violation of Section 12.01 can be a crime, serious stuff, and that obligations cannot be waived. So as a practical matter, how does this work? Let's consider some typical circumstances. Let's see. One issue that we see coming up repeatedly, and I think it exists in our estate case that I described, is the question of whether galleries can hold on to artist works after the artist-gallery relationship has ended. So, and this comes up in various scenarios. I'll start with sort of a case that's off-cited. Joe Zucker was the artist versus Herschel and Adler Galleries. And when the relationship between Zucker and Herschel and Adler Galleries was completed, Joe Zucker asked for his works back from the gallery. And the gallery responded, and here's some of his works. I'm not sure these were the consigned works, but these are his works. And the gallery responded by saying, that's fine, I'll give you your works back, but before you do that, I want you to pay us $36,000 in loans that you owe us. and into the gallery. And until you pay the loans, we're going to hold on to your artworks as security. And Joe Zucker, instead of paying the $36,000, sued Herschel and Adler Galleries for an order that, irrespective of whether he owes the money, we'll deal with that over here, they have to return his works now on his request. And the court rejected the gallery's position. The court looked to section 12.01, and it's at a plain reading of section 12.01, requires the gallery to return the works and bars the gallery from having any kind of security interest in the works that it was holding. The court referenced the statute's, express language, providing, as we looked before, that the work that it holds is trust property. And then most importantly for this question, it looked at the language that's highlighted there that says no such trust property or trust funds shall become the property of the consignee or be subject or subordinate to any claims, liens, or security interests of any kind whatsoever. A couple of interesting side notes is that in the case, the gallery had to deal with this language, but it also looked to the legislative history of section 12.01 in the Arts and Cultural Affairs Law, and it argued that really what the legislature meant was that security interests asserted against the gallery by the gallery's creditors should not be allowed to be asserted against the artist's property that the gallery is holding. The court, which rejected that claim because of the word in this language, I'm looking for it, any cannot be subordinate to any claims. The court said the statute unambiguously bars all security claims, not just against the gallery, but also against the artist. But notably, the court actually also said that they thought that the reading of the legislative history was both insightful and cogent, but nevertheless, they were not allowed to overrule the actual language of the statute with the legislative history of the act. So Herschel and Adler was out of luck. It had to return Joe Zucker's works, and Joe Zucker was awarded custody of the works. And notably, this was some years ago, the Zucker and Herschel and Adler case. And I think it's notable that even since then, in the intervening years, the New York legislature has not stepped back in to change the statute, despite the cogent and insightful reading that Herschel and Adler had advanced. And just to be clear, and I think this matters, is that the works, I mentioned that there are some waivable, mostly the statute is not waivable, but there are some exceptions. This is not an exception. There's no, as I read it, there's no exception that says, for example, in a writing, that an artist in a gallery can agree that the gallery can have a security interest in the artist's works. So, nor can, some third party come in and have a security interest in the artist's works. So the Zucker ruling, in our view, plainly bars a gallery's holding work as leverage to recoup funds a gallery owes to that the artist owes to the gallery. And then the question is, what's the scope of this rule in other circumstances? I'm obviously hopeful that this rule applies to a gallery's attempts to recoup funeral costs for an artist. I think maybe that's the tantamount to a loan. We also recently encountered a gallery where the artist had left and switched to another gallery, and the gallery had, and it was a little bit of a dispute, but the gallery took the position that it had advanced studio costs for the artist and that the artist owed them some hundreds of thousands of dollars in studio costs, and they were refusing to return an important painting of the artist, which was, likewise valued at several hundreds of thousands of dollars. And we pushed back very hard on the gallery, saying that they're not allowed to do that, that these two issues, whether our artist gets the work back and whether the artist owes studio rent, are absolutely separable, and that we wouldn't negotiate one against the other. And basically, we gave them Zucker, we gave them the Cultural Affairs Law, and we said, if you don't give, if you don't give the painting back, we're going to sue you. And we intend entirely to negotiate in good faith the rent issue, but we're not going to do it until we have the painting back in our possession or in our client's possession. And they, smartly, and I think, respectfully, they relented and they agreed and they returned the painting. And then we had a good faith negotiation with them over the rent obligation, and we were able to work that out. Another sort of brewing related issue involves the Artist Pension Trust, APT. I don't know how many, I see some nods. Some people know about APT and its machinations, I think. APT, for anyone who doesn't know, was an investment pool, an investment vehicle set up 20 years ago, I think, 15, 20 years ago, for artists to pool their interests, to pool their interests and put works of theirs into particular investment pools on consignment. And then when works got sold, the proceeds of the sale were to be split in a particular way. But where the artists got to, by putting in their own art, they were able to invest in the art of others and share the proceeds as the thing went forward, which was, it was an interesting idea because, as you're sitting here today, we don't know who's going to be successful 20 years from now. So it's sort of an interesting idea to pool your interests. Unfortunately, generally, I think the whole thing crashed and burned for various reasons that we don't have to talk about today. But this fall, or maybe I guess in the summer, APT announced that it was closing its New York investment pool, which was a group of artists, mostly from New York, and they sort of named their pools by various geographical locations. And in saying that they were terminating the New York investment pool, they very kindly said, and we want to give you your art back, and we're just going to keep 30% of it to pay for our costs. And, some artists actually, sorry, I think I have a slide. There's my APT slide, and I think the highlights there, they're wanting to keep 30%. We'll give it back to you according to the following percentages: 30% to APT and 70% to the artist. Of course, there was no contract that warranted doing that. And our view is certainly that it is not consistent with APT's obligations under the Arts and Cultural Affairs law. And while some artists, just as a practical matter, acquiesced and said, fine, give me 70% of my artwork back and I'll be done with you, some have not. And we'll see whether, how that works out or whether some litigation will ensue. A related issue, one other last related issue, I think, on this front is a question of money as opposed to artworks. So meaning, what happens when the artist leaves the gallery and they're sort of offsetting claims to money? And so the gallery owes the artist money for sales proceeds, the artist owes money back, whether it's for studio rent or for production costs or loans and the like. And the artist Jeffrey Gibson, who recently represented the US at the Venice Biennale, maybe some of you were lucky enough to go, I missed it sadly, several months ago sued the gallery, the Kavi Gupta Gallery, under the Cultural and Affairs law for $638,919.31, are saying, and it seems likely accurate, that he's owed that amount of money from sales that the gallery had made of his work. The gallery has asserted counterclaims against him, looking for an offset of some, I don't know the amount, but some monies that it invested in the creation of his work that they say were reimbursable production costs that I suppose were supposed to come off the top of any sales. So there are these conflicting claims to two different pots of money. And the case is proceeding, so it remains to be seen how the court will deal with these competing claims. And in particular, what we're watching for is to see whether the court will split the issues and allow Gibson to recover the monies owed to him in some kind of expedited way, where the reimbursement issue is litigated sort of more in the natural course, because he disagrees about what the amount of the reimbursement was for and whether certain types of costs were to be shared or whether the gallery alone was supposed to bear them. And sort of in litigator parlance, we're wondering if there's going to be some kind of quick, cut to the chase summary judgment motion, those of you who practice, that kind of tries to bifurcate the case between the issue of Jeffrey Gibson getting his money and the issue of whether there are reimbursements owed. And obviously, in thinking about it, we think that one would look to the cultural affairs law and to the line that we saw before that says that the proceeds of a sale are trust funds and should be, and to me that means that they are actually the artist's money, even though they're in the hands, it's in the hands of the dealer, and that they should be released, at his direction, even if the gallery has claims back for other monies. So that's sort of the security interest and the use of art and funds as leverage to kind of even up after an artist leaves. Another issue that comes up repeatedly, and we see again and again, are disputes over a gallery's purchase or supposed purchase of consigned work. And again, we have this issue in the estate case estate matter that I described in the beginning, where the gallery says it purchased works, but of course has yet to come forward with any written records showing the purchase. So one foundational case or off-cited case is the case of Kaldi versus Kaspiev. And here you can see some photographs by the Russian photographer Eugeny Kaldi. And his heirs, after he died, sued Kalman Kaspiev, who had acted as Kaldi's agent, seeking to retrieve 262 prints of Kaldi's works, photographs, that had been delivered to Kaspiev. Kaspiev defended and tried to hold on to the prints. And he said that, and these prints had been, this case was decided in 2015, and he'd had the prints had been delivered to him maybe some 15 years earlier. And he claimed that when the prints were delivered to him, he paid $7,500 for a 50% ownership interest in the prints. So it wasn't a full ownership claim, but this partial ownership claim that he made. And he also claimed that in the intervening years, he had returned 135 of the 262 prints. So there sort of were two groups of prints, the ones he says he returned, 135, and then 131 that he said he had a half interest in. The court very quickly decided that the prints were delivered to Kaspiev in his role as an art merchant for sale and for payment to him. So therefore, the section 12.01 applied. It then had to look at the two issues, which is, what do we do about this pesky 50% ownership interest that Kaspiev says he has? Does that entitle him to keep the works, to hold on to the works and sort of control them until they're sold? And what do we do about the claim that he returned 135 of them? So as maybe you can guess from our preview, this did not go well for Kaspiev. He was a fiduciary and he was holding trust property. So the court looked at what does that mean under section 12.1. First, the court rejected that Kaspiev actually had a 50% ownership interest, even though it was, he said he did and they said he didn't. So it was sort of a classic dispute. But the court looked at at the cultural and affairs law and concluded that a gallery's investment in an artist or partial investment in supposed ownership of works doesn't actually transform a consignment into a sale unless, and as section 12.01 says, unless and until, sort of the end of this, until the price is paid in full to the consignor, meaning either there's a full disposition of the ownership or there's no disposition of the ownership. So the court concluded that the Kaldi family continued to be the owners of all of the works and owning 100% of the works, and just disregarded this notion that Kaspiev bought a 50% interest. And then the court also turned to the question of the 135 supposedly returned prints. And the court did what I think would be typical in an instance where works were delivered to a fiduciary. It said the burden is on the fiduciary, on Kaspiev, to prove that he returned the 135 works. He was their agent, he was their fiduciary, his say-so, his word alone wouldn't be good enough. But be that as it may, Kaldi admitted he had no records documenting that he had returned the prints at all. So the court found that he would be liable for damages for having lost 135 works, in addition to being required to return the other 131. So, Caspia fell victim to two things. One, a misunderstanding of the Arts and Cultural Affairs law and this notion that you could just buy some percentage ownership off of your artist client and co-own works together, which I guess is an interesting thing to think about in this, moment where there's so much co-ownership of works and people, changing the ownership of works by percentages. And then he also fell victim with respect to the return of the works, to the his failure to document that the works were returned. If he had documented the 135 works being returned, he probably, it may well have been found, or likely would have been found that that happened, and that he wasn't liable for them. Not sure what's happening with my PowerPoint.
I think it might be a signal that we're running a little tight on time.
Okay, so let me just very quickly wrap up. I'll take the signal, Bill. But I want to just say, with respect to this question of ownership, which I think is interesting, we recently litigated a case for the artist Raymond Pettibone against what's now the bankrupt Ace Gallery in Los Angeles, which was run for decades by the gallerist Doug Christmas. And after Ace filed for bankruptcy, the bankruptcy trustee turned up 27 drawings by Pettibone in Ace's warehouse, where they'd been sitting for about 3 decades. And when they popped out, Doug Christmas claimed, oh yeah, I'm familiar with those drawings. I bought them from Raymond in 1988, 1989 with cash. And that was his story. In discovery in the case, we located consignment forms showing that Raymond had consigned the works to Ace Gallery, and no documents appeared showing that there was any kind of sale to Christmas or to Ace Gallery or to anyone else. And in the summary judgment opinion that's in your packet also, the bankruptcy court concluded that Doug Christmas's word alone was insufficient to create some kind of issue, and awarded ownership of the 27 drawings to Raymond. So again, the takeaway from that was that a sale between the artist and gallery should be documented and should be, in writing and signed by both parties. And I'm not going to go through it, but the last thing I was going to talk about very briefly was about commingling of funds. And obviously,
You'd have to talk over me making like the music
well, maybe
on
you'll ask
the
me
Oscars.
You want to ask me a question about commingling of funds?
Yeah, I do, but I'm going to do it at the end, so we can.
Anyway, thank you for your patience. I hope this was
No, thank you very much, Greg. That was excellent. Let me also, for attorneys attending who wish to receive New York State CLE credit for this panel, please record the following code. Topics, capital T, lowercase OPICS, 46, capital Z. That's topics with a capital T, 46, capital Z. Okay, so we've done the money, we've done the lawyers, and we're going to end with the guns with Yael, who is counsel at Friedman, Normand, and Friedland LLP. Yael advises clients in a wide range of domestic and cross-border art and cultural property matters. She has broad experience representing clients in complex commercial art transactions, including auction and private sales, purchases, consignments, and loans. She's represented claimants in actions seeking restitution of art misappropriated during the Holocaust and claimants seeking the recovery of looted or stolen cultural patrimony. She's going to be speaking about that very topic. Yael, it's yours.
Thank you, Bill, for that introduction. It's great to be on this panel. I did have a PowerPoint, but we'll just go with that. So I'm going to be speaking, as you heard, about Nazi looted art and colonial repatriation. And I thought I would start with a question that is the subject of some debate in the context of Nazi-era restitution, and that is, when is a sale or other transfer of art considered involuntary and therefore void? In New York, courts have been less than consistent on this issue. So recently we had a case, Robert Owen Lehman Foundation versus Zirkle, which involved a 3-way dispute over the ownership of an Incan Chile drawing entitled Portrait of the Artist's Wife. And I did have a picture of that, but we'll just, you can look it up. So on the issue of duress, the New York Supreme Court held that even though there was no evidence to support a finding of a forced sale, the artwork was involuntarily transferred by its original owner due to conditions of duress that were caused by the Nazis. The claim for this artwork arose after it had been consigned in 2016 for sale at Christie's by the Robert Owen Lehman Foundation. And Lehman had come into possession of the work when his father gifted it to him after the two had seen the drawing at a Sheila exhibition in London in the 1960s. After it was consigned in 2016, Christie's flagged the work, but its research did not result in an uncontested narrative, and litigation ensued. And the parties claiming ownership to the artwork included the heirs of Heinrich Rieger, who was a Jewish art collector and dentist in Vienna, and he was actually Sheila's dentist. Side note, Sheila is known to have occasionally paid for his dental work with artworks and painted Dr. Rieger. The other claimants were the heirs of Karl Mailander, who was a Jewish businessman and art collector also living in Vienna, and who Sheila is also known to have painted. Sadly, both Dr. Rieger and Karl Mailander were tragically murdered by the Nazis. So, with respect to the Rieger heirs, the court held that there was insufficient evidence to support their claim, and also added in dicta that the claim would be barred by laches. And the Rieger heirs have filed a notice of appeal. With respect to the Mailander heirs, the court held that they had established superior title to the drawing for purposes of their counterclaims of conversion and replevin. And in reaching the ruling, the court took into consideration the Washington Conference principles and the intent underlying the HERE Act. And I thought I'd run through some of the facts that the court looked at in finding the duress. In 1941, Mailander had been deported to a ghetto in Poland after he had unsuccessfully sought to flee Austria. Sometime earlier, Atelka Hoffman, who was not Jewish, took possession of his art collection. And the exact circumstances of their acquaintance is unclear. In 1960, Ms. Hoffman sold the drawing, along with several other artworks, to Rudolf Leopold, who many of you might remember from the Portrait of Wally case. And from there, the work eventually ended up at the London Gallery, where it was acquired by Lehman. The court held that the transfer from Mailander to Hoffman took place due to, quote, conditions of extreme duress and anti-Semitism. Thus, the transfer was held to be involuntary. In reaching this holding, the court distinguished another recent decision called Benningsen versus the Guggenheim, which I'll speak about next. I should mention that my colleagues and I represent the plaintiffs in the Benningsen case, and it's currently on appeal. So the Benningsen case involved a claim to a Picasso artwork called Woman Ironing, which was dismissed this past June. The plaintiffs alleged that the painting had been sold as a result of Nazi duress after Karl Adler, who was a German Jew, sold the painting in 1938 in order to raise sufficient funds needed for his flight from Germany to South America. The work was sold to the art dealer Justin Tannhauser for what was alleged to be an exceedingly low price of approximately $1,500. The court dismissed the claim as barred by laches. But on the question of duress, unlike in the Lehman Foundation case, the court held that because the threatening circumstances originated with the Nazis and not the other party to the transaction, there was no duress. The court provided a few examples of what could support an inference of duress, including confiscation, a direct purchase by the Nazis, a forced liquidation through a Nazi auction. Those were some examples. And the court also held that there was no third-party duress on the grounds that Tannhauser didn't know or consent to any direct consequences if Adler failed to sell the painting to him. So the court there took a much narrower view of duress. And as I mentioned, the plaintiffs are currently appealing. The next matter I'd like to discuss involves claims by the Grunbaum heirs, which many of you know underlie both Reif cases and Bacalar, as well as recent activities by the Manhattan DA. So I'll give just a brief background on the facts there. Fritz Grunbaum was a renowned Viennese cabaret artist who was arrested by the Nazis in 1938 before, sadly, being sent to his death in Dachau. While he was in a concentration camp, he was forced to sign a power of attorney, giving his wife the authority to permit a Nazi inventory of the property, which included his art collection. And the art was then deposited in what was alleged to be a Nazi-controlled shipping company. Now, in the Bacalar case, which was decided in the Southern District of New York, the court held that the artwork there was not looted and Latches barred the claim. And on appeal, the Second Circuit affirmed on Latches grounds. In the New York state courts, in Reif v. Nagy, they took an opposite view, holding that the transfer of art that followed the power of attorney was void as a product of duress, and Latches didn't bar the claim. So most recently, I'm sure you've all seen news of this, the Manhattan DA has gotten involved, seizing numerous artworks that came from the Grunbaum collection on the basis that the works were confiscated by the Nazis. So far, the DA has returned a total of 11 artworks to the Grunbaum heirs, including from Museum of Modern Art, Morgan Library, and others. All have agreed to return the Sheely works with the exception of the Art Institute of Chicago, which is currently litigating over a Sheely drawing called Russian War Prisoner. In November of 2023, the AIC prevailed in a prior proceeding against the Grunbaum heirs, and I believe that's currently being appealed. In the meantime, separately, there was an oral argument with the DA and the AIC earlier this fall. So the last hot topic that I'd like to discuss in terms of Nazi-era restitution is about the legislation that was recently enacted in California, just signed by Governor Newsom on September 16th. The law came in response to a controversial decision by the Ninth Circuit in the Kasserer versus the Thyssen-Bornemisza Collection Foundation. The Ninth Circuit determined that under California's choice of law rules, Spanish law and not California law applied. And under the Spanish Civil Code, the Thyssen-Bornemisza had gained prescriptive title to the painting. Rehearing was denied earlier this summer, and a petition for cert is expected to be filed with the U.S. Supreme Court later this year. The law, which is entitled Recovery of Artwork and Personal Property Lost Due to Persecution, mandates that California substantive law will apply in actions such as the Kasserer case that are brought by California residents or their heirs to recover art taken by the Nazis or due to other acts of political persecution. The law is broadly drafted, to apply to all actions pending on the date it becomes operative, including where judgment is not yet final or the time for filing an appeal has not yet expired, or where a petition for cert to the Supreme Court has not yet been decided. So as the Kasserer case is still pending and they're expected to be filing the cert petition, they will have the benefit of the new law. So switching gears a little bit to colonial repatriation, I thought I would talk about the Benin bronzes, which have become emblematic of a movement in recent years to repatriate colonial art and to right, at least in some way, the wrongs of the past. The bronzes also highlight some of the complicating factors that can arise in repatriation matters, even when the looting itself is clear. The Benin bronzes consist of some 3,000 pieces of cultural artwork that were created in the former Kingdom of Benin, located in present-day Nigeria, including ceremonial swords, statues, ivory works, and other objects, which were looted by British colonial troops in 1897, when the troops invaded and captured the king's capital. And today the artworks are scattered all over the world, especially in Europe and the United States. In October of 2021, Jesus College of Cambridge University became the first institution to return a Benin bronze to Nigeria. And this was followed by several other returns, including by institutions in the US, such as the Metropolitan Museum and the Smithsonian. But in the spring of last year, the Nigerian government declared that the current Oba of Benin was the rightful custodian of the artifacts. And this led to some controversy as institutions and governments were left to navigate who to return the artworks to, the Nigerian government or directly to the descendants of the family they were stolen from. The announcement also raised some questions about whether the objects, once restituted, would be open to public view. But in July, the University of Iowa Stanley Museum of Art restituted its holdings of Benin bronzes to the Oba of Benin, marking a first in the US. One other update I'll just mention related to the Benin bronzes. So the Supreme Court recently denied cert by the Restitution Study Group, a New York-based organization led by Deidre Farmer-Pellman, who had filed for cert in an appeal challenging the Smithsonian's decision to restitute the Benin bronzes to Nigeria. The lower court dismissed the case on the grounds of mootness. Farmer-Pellman has been outspoken in her opposition to repatriation, pointing to the historic links between the bronzes and the ancestors of African Americans who were sold into slavery in exchange for the metal used to create some of the Benin bronzes. So although cert was denied, bringing to a close the question of the Smithsonian's authority to return the bronzes, the issue raised by the petition, in my view, highlights the complexity and emotional aspects that are involved in all of these cases.
Thank you, Yael, very much. I just want to turn to your part of the discussion about the Manhattan District Attorney's Office and their involvement, because they indeed made quite a splash into this area of law. And they did so while civil cases were pending involving the same parties. So like in the case of Art Institute of Chicago, they actually won in their federal civil case. So the claim was denied, but they might lose in the criminal case that the ADA is pursuing. And I'm just curious if you think that the ADA's entrance into this area signals like an erosion of the civil claim of replevin. I mean, if you're a claimant, why trouble yourself with the risk of statute of limitations or laches defenses? Why not just knock on the door of Mr. Bogdanos?
Well, I think that cases with the DA are probably more the exception than the general rule. I mean, I'm not sure that their involvement in this case necessarily signals a trend that they'll get involved in other Nazi looted art cases going forward. So, you know, while, you know, it's exciting to kind of follow the proceedings in this case and to see how the two are kind of coming up with different, you know, maybe different outcomes or not. But I'm not sure that it's going to necessarily erode, you know, these civil cases necessarily going forward.
All right, thank you. I do want to open it up. We have a few minutes for questions. Before, though, I have a question for Greg. Something about consignments, I believe.
What is your question?
It was an alley-oop. You said, ask me something about consignments.
So
I could ask you another one, but
I think what I was going to mention, just you know, in closing, was the question of commingling of funds and trust funds. And I think to the extent that we have gallery clients, you know, a top line issue for them and advising them is to let them know about the fact that sales proceeds are trust funds. And like lawyers holding funds, you know, retainer funds or settlement funds or whatever for our own clients, when we want to put those, it's important to us to keep those amounts segregated. And we do that generally by having a separate bank account. And, to the extent I've had the opportunity to advise clients, and I would again, gallery clients, I would advise them that they should have a separate account for collecting sales proceeds, and all sales proceeds, just like, frankly, we do with settlement funds in our cases, should go into that separate bank account. And if the gallery is owed something in connection with the sale, it should then be paid out of that separate bank account, and it all should be documented. And too often, we see it in whether it's galleries or art advisors or lawyers too often, our clients get ahead of themselves and start using sales proceeds and other monies for purposes that are not, what they're there for, on the, sometimes right and sometimes wrong hope and expectation that, it doesn't matter if I use artist A's money to pay artist B because I've owed our artist B for some time now, and I'm pretty sure I'm going to make a sale next week. And sometimes that sale next week just never happens. So, the way to protect our gallery clients is to really do everything we can to have them follow that practice and not commingle funds.
All right. Well,
thanks for that toss up. That was a good question.
Right?
Very important.
I went to law school. And I'm getting a signal that we've actually, exactly as we drew this up, taken it down to the last minute, so we are good. But everybody will be still available at the coffee break, so if you have questions, please come up. And otherwise, thank you all to our panelists, and thank you to the Appraisers Association.
Great. Thank you so much, panelists. We have a short break, so please be back in 15 minutes. And then we'll have our next to last and our last panel.
But on different issues, so who knows? I don't know. God knows. I just want to make sure I understand. If they do something, in turn, it's not a consent to the law. You know, wasn't it? And then they came up with this answer. Maybe that was. It was California, so maybe I'm crazy to, boy, that's pretty daring. You still have an active citizen to say, you know, like throughout the empire, the umpire. Okay, so I am correct. Okay, all right, interesting. So when was it, when did they actually file their claims for sure?
Last I saw was
But, you know, I think that one of the reasons why.
And that allows me
Yes.
to undo this. Fair enough.
Welcome back, everyone. If you could grab your seat. Before we get started, I just want to thank DLA Piper for being our barrister sponsor. We're very excited. He's a new sponsor and a wonderful firm. Okay, our next panel is NAGPRA and the STOP Act. This panel is moderated by Eden Burgess of counsel at Schindler, Cohen & Hockman. Eden has focused her legal career on the cultural heritage, the arts, and historic preservation. Eden represents a diverse array of clients, including museums, auction houses, collectors, foreign states, nonprofits, Holocaust victims and their heirs, and Native American tribes. I now turn it over to Eden.
Thank you, Linda. I appreciate that. And thanks, everybody, for having us today. I think we put together a really interesting panel of some of the top minds on these topics in the country, so I feel very fortunate to be able to hear directly from these folks today. So we're going to start with Shannon O'Loughlin. Shannon is the chief executive of the American, I always forget the name of it, the Association on American Indian Affairs. And she's also a citizen of the Choctaw Nation of Oklahoma. She's also a lawyer, so she can speak many languages, so to speak. She is on the board of the Potawatomi Ventures, which is an economic development corporation, and she was formerly on the Cultural Property Advisory Committee until she was fired by you-know-who, whose name shall not be named, in 2019 when he entered the White House. So I will say I've known Shannon for a long time personally, and she is tirelessly committed to these kinds of issues and trying to ensure that the tribal nations in this country get what they need to get and are respected in the way that they should be. So Shannon, I'll turn it over to you.
Well, hot damn, all right. Are we ready? It's Friday. You're almost done. How are y'all doing? If you'd like to take a collective deep breath with me, that's what I'm going to do right now. It's been a week. Thank you for having me here. I'm honored to be able to come to the land of so many Native people who once occupied this place. And I'm here to talk, well, I guess I need to turn on. I'm starting off really well, right? Here we go. We're here to talk about, during my presentation, why Native nation sovereignty affects appraisals, why it affects you as a lawyer, as an appraiser, as a human being. And these are issues that most people don't know a hell of a lot about. And so I'm going to not get into the minutia because it's quite a complex field of law. It's kind of like the law of war or immigration. It's a completely separate body of law that doesn't follow a lot of common sense. Or logic and reason sometimes. So let's get started. Why do you need to understand this? It's not just because it's interesting or that it gets into history, but that it's important because your competency in looking at Native American items is dependent on the history and the law that applies to Native peoples and Native nations. And what's been interesting to me in my practice as an advocate for a Native organization and as a Native person is that when I've tried to work with collectors, when I've tried to work with auction houses and dealers, there seems to be an absolute ignorance or just a whole out ignoring the body of federal, state, and tribal laws that apply to the issue of Native cultural heritage. In addition, it's well known that provenance and provenience information is doctored all the time for many, many reasons. And that's not any different in the area of marketing our precious and sensitive cultural heritage items. And of course, you know that your ethics, appraisers specifically, mandate a level of competency, non-discrimination, certain conduct, and evaluating title in a way that urges you to get more training than what you're going to hear today, right? If this is an area that you're in, you need to do more work to make sure that you understand the issues we're going to talk about today. By the way, the pictures I have on the slide are pictures from some of your sponsors who are selling cultural heritage items. There's a rattle, I think a Tlingit rattle at the bottom there that was sold by Bonhams for about $500,000 and some odd. It was an object created in the 1700s as cultural sensitive patrimony. The other items are items for sale by heritage auctions. All right. So let's talk a little bit about Native Nation sovereignty. So Native Nations, by the way, they're not a special interest group. They're not classified as a race. Native peoples and Native nations are political entities, and that's because Native nations are recognized by the United States as having inherent authority over their lands and their people. And they've been called in foundational U.S. Supreme Court cases, such as the Marshall Trilogy. In the 1830s, Justice John Marshall declared that Native nations were separate domestic sovereign nations. Native nations are recognized in the U.S. Constitution under the Commerce Clause and elsewhere. Most importantly, treaties are the supreme law of the land, as we're aware, and there have been many, many treaties between the United States and previous colonizers and various Native nations. And of course, there's a huge body of federal law, which is known as federal Indian law under 25 U.S. Code. So please be sure to go in your law library, if y'all still do that. Still have law libraries? And look at 25 USC. That's where you'll find historic and contemporary laws. And Congress has the authority to pass laws pursuant to its trust responsibility, its government-to-government relationship with Native nations. It's also known as a duty of protection. We gave up lands and resources for specific promises that included the duty of protection, and often also included the duty of protection against bad men. So bad men were usually states and state citizens. And there's 574 today. There's 574 recognized diverse Native nations in the US and Alaska. Each one of those has their own body of laws, a governance system. They have their own social services, education programs, childcare, everything you would think a government would have, Native nation governments have. And only Congress has the authority to remove any vestige of Native nation inherent sovereignty. And by the way, Congress has not removed Native nation inherent authority over our cultural heritage. And you'll find in many Native nations' own laws, including within their constitutions, because many have written constitutions and have similar forms of government that they've adopted that are similar to our Western structure. It was kind of forced on them, but some continue to use that. There's many who include the right to assert jurisdiction over their cultural heritage wherever it may be held. But regardless of this huge body of law that protects Native peoples, was I even talking into this thing before? Is it not close enough? Regardless of that huge body of law and this duty of protection that the U.S. has bound itself to with Native nations, the government kind of left unchecked the people, its own citizens, and the taking of, okay, this was, I'm not sure if I'm going to be able to play this map. So there's this wonderful map I was hoping to show, and it's a video, it's a YouTube video, and so let me just, I don't think we'll be able to show it, but I hope that you can look it up fairly easily. What it shows is the disposition of about 1.5 billion acres of land between 1776 and 1887, which continued, the loss of land and resources continued through agreements and through violence until about 1934. And so, by the way, the Association on American Indian Affairs was an organization that began in 1922, and one of the first things that it did in which was passed in, I think, 1934, was the Indian Reorganization Act, which put an end to that land taking, that divvying up land and giving individual Indians 160 acres. But what I was wanting to show from this video is I was hoping that you would take a moment to imagine what it might have been like to live in the United States as a Native person over that, whoops, things are moving. Oh, someone's gonna play it for me. Yes, thank you. I see little mouse buttons going. If you can imagine what it might be like to lose your home, to lose the places where your family has been for 1,000 years at least, the grave sites, your homes with your culture and your religion, your sacred places, what it might be like to lose all of that and be forced to live on reservations. Quite often they were far from native homelands, especially if you were originally from the eastern part of the United States. Throughout this period, there was continuing, how am I doing? Forced assimilation and removal under federal law. And one of the biggest assimilation policies that came in the 1800s and continued into 1960 is the boarding school era. You may have heard about some of this in the news. Currently, the federal government has uncovered that there's been 417 schools and more than 1,000 other institutions that brought Native people in away from their family, and particularly with boarding schools, took children away from their families and forced them to go to these boarding schools in faraway places, cut their hair. They could not practice their culture, speak their language, and quite often they were physically abused, emotionally abused, and learned how to abuse one another, right? So the history of Native peoples is beyond duress. Our culture was taken from a word that I can't even think of that's much more complicated than duress. And the statistics, the harm that this has caused to us, even today, we have the highest rates of suicide in our young people than any other group. We have some of the highest rates of health problems and heart attacks, diabetes, car accidents, you name it, we got it. but we're still here. And what we've learned is that when we're able to practice our culture and revive and revitalize our identity as Native people through the manifestations of our culture, healing happens. And so that is another reason why it's so important for you to understand not just the law, but the history of genocide and assimilation on this continent that has dispossessed Native people of their cultural heritage and put them in auction houses around the world. All right. So I want to just kind of share with you how complex this body of law is. So I've just listed a few, and I inadvertently left off the Indian Arts and Crafts Act, which is specific to fraudulent items that are labeled as native made but are not. And so we're seeing a lot of fraud in the marketplace with native items, especially Southwestern items. But let's look at some of these laws. Most of these laws, the early laws were devices to stop the wholesale just digging up graves and items. There was so much context that was lost by the looting and taking of native items, native bodies, and those burial belongings that went with those burial bodies, that laws were passed, like the Antiquities Act, to stop that kind of amateur taking of cultural heritage. Now, that wasn't for the benefit of Native peoples. It wasn't until later laws where Congress affirmatively passed legislation that was meant specifically to protect Native nation sovereignty and self-determination and reassertion of those cultural rights. I want to make sure that you're aware of some of these dates, that there's laws pre-1970. I know, what isn't it, 1970 is a big date in there's laws pre-1970 that could apply to a cultural heritage item that you're looking at. And by the way, I'm using cultural heritage item instead of saying antiquity, instead of saying artifact, and instead of saying art, because these items are none of those three. Those are labels that the market and museums and institutions have placed on them, but that is not the true identity of these types of items. 5 minutes, great. All right. So today we see some really strong laws that have come forward, and we'll be talking about the Native American Graves Protection and Repatriation Act, the Protect Patrimony Resolution, and the Safeguarding Tribal Objects of Patrimony that were passed to protect Native rights to their cultural heritage. Know that these laws fall under the big federal Indian law umbrella, and they should be read under that context, which means there's canons of construction about how these laws are interpreted, and it's for the benefit of Native peoples. NAGPRA is considered a human rights law because it's not for institutions, it's not for museums, it's for the benefit of Native peoples and Native nations. And in addition to these few laws that I've listed here, please note that depending on the provenience of an item, there are state laws that are potentially applicable to a cultural heritage item, as well as tribal laws that are applicable. So if you're not looking at those things, you're not doing a competent analysis. Ooh, ooh. Can I do it again? Oh, man. Okay. All right. So what assignment conditions do you have after these few things I've quickly talked about? I mean, can you assume that the provenance or the chain of custody is correct? What if you're just given a bill of sale from the 1980s? Is that enough for you to determine whether the holder of the item is the appropriate owner? Most auction houses and dealers and experts in the field often rely on NAGPRA as the piece of legislation they need to look at. And as I've just went over, there's way too many laws. There's clearly a need for expertise in this area that has not been, that we have not seen out in the market, because NAGPRA is not the only law that applies here. I mean, how do you appraise an item when you're aware that these objects came from a native nation, that the federal government has defined certain types of cultural items under NAGPRA, for example, as items that can't be dispossessed from a native nation without free, prior, and informed consent. Even though NAGPRA doesn't provide a remedy when a private collector holds these items, the federal law is still really clear about what types of items are communal property or are national cultural patrimony that cannot be obtained without proper authorization at the time of the taking. So how do you appraise without consulting those native nation governments? And how do you do it without being discriminatory? NAGPRA was actually passed because Congress recognized how native bodies were treated differently than anyone else's in a marked or unmarked grave. So how do you appraise these? I wanted to bring these items to your attention. These are wampum belts. They are, these specifically are wampum belts from the Haudenosaunee people. I won't get into the details about these. These are amazing, amazing items. These are national cultural patrimony that would be like a treaty document. Right? These are agreements between nations that you're looking at right here. One of these items is repatriated. The other one was sold or was put up for sale at Sotheby's. Can you tell the difference? They both have similar provenance and provenience. But one was out on the market that we worked really hard to get off the market. It finally, 10 years after it was sold at Sotheby's, one of the holders found a Haudenosaunee leader and gave the belt back kind of in secret. That's a whole nother story I don't think I have time for. But I want you to consider that the items that you're looking at are no different than the items that are being repatriated under NAGPRA law. And there are, boop, oh, I didn't even touch it that time. Okay, thank you over there. I want to, because we have such little time, I want to provide you a few resources to get more information and more training. Melanie's coming up next. She's going to talk about NAGPRA, but the National NAGPRA program has some great and easy training that you can access now through videos. The Association on American Indian Affairs has an annual repatriation conference every year. And we're also developing an online training platform that will be free, that everyone will have access to about NAGPRA and other repatriation mechanisms to support the return and healing of for Native people. So I really appreciate your time today. Thank you, Yakoki.
Thank you so much, Shannon. It was important when we were planning this panel that we started with Shannon, because a lot of the areas she mentioned, tribal sovereignty, are little understood, often disrespected, and rarely applied in the way that they should be. So those concepts underlie everything that Melanie's going to talk about, and also the sort of litigation, lawsuit, regulation world that Greg is going to talk about. So next, I'm honored to introduce Melanie O'Brien. She's the manager of the National NAGPRA program and carries out administrative responsibilities on behalf of the Secretary of the Interior, and that's done through the National Park Service. So unfortunately, she couldn't be here in person, but she was generous enough to do the Zoom thing. So Melanie, go ahead.
Hi, can you hear me?
I'm sorry, let me pause you right there. Can you read sorry, I need to read the CLE code. So, yes, thank you. So the code is NAGPRA, NAGPRA 95W. Again, NAGPRA 95W. Okay, Melanie, thank you.
All right. Thank you, Eden. I don't think you all can see me in the room, but just hear me. Is that right?
We could see you a second ago, but I think they've got to work. But we can hear you fine.
Okay, great. Well, thank you again for the opportunity to speak with you, you all, and I appreciate. I apologize that I couldn't join you in person today. I did want to give you just a little bit of background on NAGPRA, the Native American Graves Protection and Repatriation Act, and especially on some recent changes to the regulations that implement that law. And in order to get that CLE credit, be sure that you look at those documents that we submitted, which included the law itself, as well as the revised regulations. As Shannon explained and mentioned, there's a long history in the United States of the collection of Native American bodies and property. And really, in many ways, the history of the United States is the history of the theft of Native bodies and Native property. You can look as early as 1620, within days of landing in the New World, the Pilgrims found burial sites, disturbed them, and as Mort's relations say, took the prettiest things away. Thomas Jefferson was one of the very first systematic archaeologists in this country, and looked at a burial mound on his property in Charlottesville, Virginia, and decided to see what was inside of it. You can read about that in the notes on the state of Virginia from 1787. So there's a long history in this country, and as Shannon mentioned, the first 300 years of the history of this country, there were no protections for Native bodies, Native property, or archaeological resources generally. It wasn't until 1906 in the Antiquities Act that the federal government started to take action in protection of those artifacts and resources. But then it wasn't until 1990 that Congress did anything to resolve the rights to those ancestors and objects to their descendant communities. Shannon's list of laws is very helpful, and one that we often point to as the precursor to NAGPRA is certainly the American Indian Religious Freedom Act of 1978. It's a crucial piece of legislation that provided the right for Native Americans to once again practice their religions in this country. Until 1978, Native Americans were prohibited from practicing freely their religion by federal law. And a big piece of practicing that religion relates to all of the artifacts and objects, and as Shannon said, the cultural heritage that had been stolen from them in the preceding 400 years. So with NAGPRA, Congress changed the course of US history and obviously changed US law. And in fact, Congress made clear that these artifacts, resources, art, property were no longer those items, but were in fact cultural heritage that belonged to Native Americans in this country. NAGPRA recognizes the rights of Indian tribes and Native Hawaiian organizations in human remains and cultural items. It establishes an administrative process to resolve the rights to those ancestors and items. There is a priority under the law on ancestors and burial property of those ancestors. And even though this law was passed almost 34 years ago to date, it was slow in its progress. Over the last 34 years, only about half of those ancestors and objects have had their rights resolved and have been made available to return to Native American people. And so the recent change is in the regulations that implement the 1990 law. Those changes have been developed over the course of the last 3 years, beginning with tribal consultation, followed by a proposed regulation published in the Federal Register for public comment. And then lastly, in December of 2023, the Department of the Interior issued a final regulation for a full revision to the regulations that implement NAGPRA. Those regulations were effective in January of 2024. And while the regulations are new, the process is not. The procedures and process in the NAGPRA regulations are simplified and clarified, and in many cases try to reset the process, this administrative work that must be done to what Congress intended in 1990, including reestablishing deadlines for completion of certain tasks related to repatriation of ancestors and items. Some important additions to these regulations, perhaps the one that you may have heard about, is an additional requirement for something that's called a duty of care. And that duty of care requirement under the new regulations requires anyone who has possession or control of Native American cultural items or custody of cultural items to consult with tribes. And the largest change really is that to obtain free, prior, and informed consent prior to allowing exhibition, access, or research on Native American human remains or cultural items. This has been reported broadly in the press as some museums have chosen to close exhibits that contain Native American human remains or cultural items in response to these new requirements. NAGPRA provides for enforcement of these requirements. There are both criminal penalties under NAGPRA for the sale or use for profit of Native American human remains and cultural items, as well as civil provisions for failing to complete the process that's required by the Act and the regulations. There's also a lot of assistance available, as Shannon mentioned in her last slide, for NAGPRA and for finding out more. Certainly my office is one of the primary places to get more information about NAGPRA and its requirements. Obviously, the new regulations provide a lot of additional information about the requirements and the process that is required under the law. In addition, there are also a wide variety of communities of practice, those engaged with this work on a daily basis who come together to share information and insight. And that's a wonderful resource. And lastly, I would be remiss if I didn't echo again what Shannon said and the assistance that's available in doing this work that comes from tribal nations themselves. Tribal law in particular, but also more importantly, tribal expertise. This work of repatriation cannot be done without that information and input from tribal nations themselves. And so I think with that, I will conclude my remarks for today, but we can certainly address any questions that folks might have at the end of the session. Eden?
Thank you, Melanie. I appreciate it. And as Melanie mentioned, we're in a real rip from the headlines kind of situation with the new NAGPRA regs, the pictures of covered exhibition halls and locked doors and signage from museums all over the country. We're on in a lot of newspaper art sections over the past 8 to 10 months. So it's very much of the moment. Last, but certainly not least, I want to introduce Greg Smith. Greg is a partner with Hobbs Strauss, and he's worked with Indian tribes and tribal organizations for nearly 20 years. He's worked on federal legislation issues, subsurface rights. He's worked with the Pueblo of Acoma on several of their legal challenges, and overall has spent much of his career working with Indian country on a variety of issues. He's going to talk today about applying the concepts that Shannon and Melanie have introduced in a sort of real life context, how litigation might work and how we might see these regs and these laws in play.
Thank you, Eden. Greetings, everybody. Thank you to the Appraisers Association for holding this event and having a panel on this area. Indian law is fairly obscure, but I remember when I was a very young attorney and first started doing Indian law about 35 years ago, which tells me it's time to update my bio. And that's what my firm keeps telling me as well. So it's been like 35 years getting my first assignment and going in. This is all pre even having computers on our desks, and going into the library, and there was US Code Title 25, and it was 5 volumes. And I was like, 5 volumes of Indian law. And that was my introduction some time ago. But I definitely want to speak about things that have happened in the courts and in the Congress in the last few years that have been part of a movement that mirrors something that's been going on internationally as well. So, for example, you'll all recall the destruction of the Bamiyan Buddhas in Afghanistan. And there was outrage, certainly in the Buddhist world, but in the art world as well, at the loss of those treasures. Similarly, the destruction of sensitive areas in Palmyra in Syria a few years back. And of course, the ongoing controversy about the return of the Parthenon marbles and whether after 2,200 years on the facade of the Parthenon, 100 or 200 years in exhibit in London is enough to prevent them from returning there. Well, for Native peoples, this is an ongoing issue with the loss of a tremendous amount of cultural material and a lot of popular attitudes that reinforce this. And I'll give you a classic example. And if you're of a certain age, you'll remember this moment. Going to the movies to see Raiders of the Lost Ark. And the opening scene is Indiana Jones, and you're all the way there with him. I'm the next Indiana Jones. And he goes into this temple, and there is an idol on a sort of stone pedestal, and he lifts it off and puts a weight on it because it's booby-trapped. And he thinks he's pulled it off, and then as he begins to step back, the booby trap, in fact, has been triggered. I think arrows come shooting at him. A big boulder comes after him. It's pretty clear that the people that put that sacred object on that pedestal did not want it removed. And we all cheered and were thrilled by the adventure of it as he escapes out with his treasure. And I think outside he met a French archaeologist who at gunpoint took it from him. And then we're all outraged that the French archaeologist had stolen it from Indiana Jones. Right? And if you go and you look at that clip and you read about its origin, in fact, Steven Spielberg was drawing from Scrooge McDuck comic books. that depict the exact same scenes. And I write about it, it's in the article that should be in your materials. But the point being that in popular culture, looting for native sites and stuff was sort of like Easter egg hunting or something. There wasn't another entity on the other side, a human being to relate to, who was being harmed, and their culture was being harmed. So similarly, this is an ongoing struggle for tribes. And I want to talk a little bit about my role in the creation of the STOP Act and the Protect Patrimony Resolution and how we put these pieces together. As background, I'm in Washington, D.C. I do both law and lobbying exclusively for tribes. My firm is about 40 attorneys. All we do is represent Indian tribes. Back in about 2015, we got a call from the Pueblo of Acoma, a very traditional Pueblo people in New Mexico, saying that a sacred shield used in one of their winter ceremonies that was stolen in the 1970s had just come up on the auction market in Paris. And the question was what to do. And I'll tell you that it's very difficult for tribes, in my experience, to speak publicly about these things. First of all, they've had so much cultural knowledge stolen and then popularized into Westerns and into whatever, movies and so forth, that one defense is to not talk about these things. On the other hand, if you don't talk about them, it's hard to stop them. And so the Pueblo of Acoma had to go through its own sort of cultural decision-making about, do we speak up about this object? Every time you do, you validate the value of the object, and it doubles and triples in value in the market. And in this particular case, Acoma said, there are families who are custodians of these objects. The family remembers the shield. They remember when it was stolen. They don't know who stole it, so we don't know if the consignor of the shield was the person who stole it. 30 years has gone by. Could have been stolen by an Acoma person themselves. There are dealers who work with Native peoples and offer money. Could have been stolen by the boyfriend of an Acoma person. There's sort of limited access up in the old village of Acoma. We're not sure how the shield left, but we know it was stolen and investigated in the 1970s, but then really almost lost to the mists of time. And then it pops up in Paris. And why does it pop up in Paris? Because if you've stolen that shield or you suspect that you have a stolen piece of property, you're not going to put it on the auction market in Santa Fe, New Mexico, an hour's drive from Acoma, Pueblo, right? So it pops up in Paris, and it actually, when it first popped up, they had such short notice they couldn't act on it, and it didn't sell. But that bought valuable time for Acoma to go through this internal process of how do you engage with the outside world. The shield was then put up for a second time, and Acoma swung into action. And the first thing they did was call up the auction house and say, that was stolen. We have witnesses. We would like it back. You know, will you return it to us, or will you tell us who the consignor of the shield is? And the auction house said, we won't help you in any way, except we will sell it to you. And you can have it back if you pay for it. And plenty of tribes choose that path. And it's for each tribe of the 574 to decide which objects are handled in which fashion. But for Acoma, that was just unacceptable. It was a complete non-starter. I'll tell you, the shield was offered, I think, for $5,000. Acoma spent 100 times that to achieve what I'm going to talk about right now. So Acoma said, no, we will not buy the shield. Tell us who the consignor is, and we will go talk to the consignor. And the auction house refused to release that name and refused, as far as we know, didn't send any message to the consignor. We were like, tell the consignor the Pueblo wants to talk to them about it. And of course, people become afraid. Like, uh-oh, what's going to happen now? Well, I have Native people outside my door, you know, doing scary things, or all the imagined fears, and knowing that real feelings, real emotions are at play over these objects. They're not, you know, to the collector, they're often beautiful, they have historical value, but for Native peoples, it's on a whole different level. And this object had been out of a winter ceremony now for decades, and now it had reappeared. And I will tell you, since then, because of this case, I'm sort of leaping to the end of the story, there were 6 shields that were stolen. This was the first one to come back. 3 more have come back since then. You know, they're flowing back, but it's quietly so. In fact, their biggest problem now, when I spoke to them just a few months ago, is we need a curator to handle how much stuff has come back. But this actually goes to a very critical point, which is about changing people's attitudes over who has a say over these objects. They're not commercial art objects intended for the market. There's tons of Acoma pottery that's gorgeous, that's intended for the market, and you should buy it and enjoy it. But that's not what this was. And these things come up, and the question is, who really owns it? And I think of something in the Harry Potter books. I got to watch my time, man. Dangerous. Okay. If you've read all 7 volumes of the Harry Potter books, as I have, and as my daughter has many times, there is a point in there where they're talking about the Sword of Gryffindor. And Gryffindor is sort of your hero house. And the Sword of Gryffindor is the signature object of Gryffindor and kind of the ultimate magical object for Gryffindor. It was made by goblins for Gryffindor. But there is a passage where they talk about how Gryffindor thinks they own that sword, but the goblins have a whole different view. They made the sword for your use, but not for your ownership. And it was a very interesting exploration in the middle of Harry Potter on whose concepts of ownership should prevail. And one of the things that our work is trying to do, of which the Association on American Indian Affairs is the oldest association in the country to work on these issues, and has done so for basically a century at this point, is to change mindsets, to have people who are upset over the destruction of the Bamia Buddhas in Afghanistan similarly be shocked to learn about how many sacred items have been pilfered or otherwise illicitly transferred out of communities where usually they're being held in a sort of communal ownership for ceremonies, and get out there on the market. And everybody was like, oh, wouldn't you like to own an actual authentic sacred item? Well, that's the Indiana Jones mentality of stealing the idol or the sacred object, but that's the creator of that item. That is an immediate and obvious offense to them. So in any event, the Acoma Shield emerges. We asked for it back. The auction house offered to sell it. They wouldn't tell us who the consignor was. In the middle of all this, a shadowy character emerges who talks to us about, I know who the consignor is. And we're like, okay, great. We're actually hopeful. Can we meet them? Well, I don't want to tell you who they are or whatever. And I go, okay, well, tell them that we're willing to talk to them about it. And it became pretty obvious that the shadowy middle figure was sort of seeing a moment of glory for themselves. And when they would convey back to us what the consignor was saying, or they claimed the consignor was saying, it didn't connect with what we were offering to the consignor. And I'll tell you, ultimately, the shield was returned because the consignor was identified. And I'm going to get to that in a moment. And there was able to be an in-person, 2 people in a room, the governor of the Pueblo of Acoma and the consignor, and the governor explaining what that object meant. And the consignor immediately said, of course you can have it back, and explained how it come into his control, and he wasn't the person who had stolen it, and so forth. But in any event, so we're not making much headway at the beginning. And the auction is coming up. This is in 2016, I think. So we work on 2 initiatives in Washington. One is the passage of something called the Protect Patrimony Resolution. And that is, it doesn't have the force of law, but the idea is to get Congress on the record and to start using that. And so a very conservative congressman, Stephen Pierce from New Mexico, where the Pueblo of Acoma is located, introduced this resolution condemning the illegal trafficking in these objects. It had as co-sponsors Mick Mulvaney and Ryan Zinke, who were members of Congress then, who went into the Trump cabinet 1 year later. And it also had Nancy Pelosi and Raul Grijalva, both stars of the liberal left in the Congress. And the point of this is, these issues were not perceived as partisan. They were perceived as, once people were educated, these are American values that need to be protected. And it was wonderful to work in Washington on something that didn't have a constant political interface with it. And that was part of what led to the success that was to follow. So that resolution passed. And right about the same period of time, the National Museum of the American Indian, which is part of the Smithsonian and is based right there in Washington, D.C., held a media event to advertise the shield and other items that were not being returned. Congressman Pierce went to that event, It was chaired by the head of the museum, who's now the undersecretary of the whole Smithsonian, but also State Department officials, Department of Justice officials, Interior officials all attended. In other words, a web of support was being created with the critical agencies to try and do something to get the shield back. And that event was held, the news story ran in 1,000 outlets around the world and splashed this on the cover. So we're now just weeks away from the shield's, the date of the auction. And I still remember the night of the auction. The auction's in France, and the shield is scheduled to come up as lot number 64 at about 2:30 in the morning. So I stayed up, and you're at lot 60, and it's whatever it was, 61, 62. You think in French, can you go a little faster? 63. And they get to lot 64, and they go, lot 64. Lot 64 is withdrawn. And that's when we knew we were gaining some serious leverage in France. And in fact, the Department of Justice had weighed in, and we talk about treaties, and one thing to know about international treaties, they have the exact same status as treaties with Indian tribes, tribal nations. They are legally the exact same status. Well, there is a treaty called the Multilateral Assistance Treaty, signed by many nation states, where they help each other in investigating crimes. And the Department of Justice invoked that treaty with the French police to say, we want you to go to this auction house and get this thing pulled. And I don't know the exact sequence of the timing, but in effect, the political authorities were speaking, and we later learned that the owner of that auction house loves to come to America and began to be afraid that he'd be arrested if he came to America. Now, I have to tell you, I'm actually not an advocate of black helicopters sweeping over remote ranches to raid them for stolen native items. I'm more an advocate, and I believe the Stop Act's ultimate value is part of this perception shift, getting people to understand that you have failed to recognize who really should decide what happens to a sensitive tribal cultural item. It should be the people who created it. And we have seen progress there. One of the art dealer associations that specializes in tribal materials has, changed their bylaws, and they lost some members. 5 minutes. Okay, but that was 5 minutes after 20 minutes. Did I get my 20 minutes plus 5? No, right, 15 plus. Okay, all right. I'm just on the top half of page 1. All right. I get into the story because it had so many twists and turns. I will tell you this. How did we find out who the consignor was and set up that meeting? Homeland Security intercepted a package from the auction house in France sent to the consignor. And the FBI went and knocked on his door. He was in a remote ranch in New Mexico. And as told to us, the FBI agents said, introduced themselves and said, we'd like to talk to you about the Acoma Shield. And the person who answered the door said, I would not like to talk about that. So at that point, but we're trying to throw the person in jail. We don't know if they were even involved in the theft. We don't know how they got the shield. But the tribe wanted to talk to them directly, human to human, which was a critical component of this. And that did occur, as I already described. And they immediately said, of course you can have it, and didn't ask for any compensation for it. The tribe readily provides notice for a tax deduction. There's a provision in the Internal Revenue Code expressly for gifts to tribes. And so, that's readily available. Anyway, to accelerate the story, the U.S. Attorney in Albuquerque brought an in rem action to seize the shield. The last time I used the word in rem was somewhere in law school. What again was in rem? An action against the property itself. We didn't know who owned or claimed to own the property. The Pueblo owned the property. So that put real teeth into things. That only worked because some Acoma individuals were willing to sign affidavits saying they were the family that was in charge of the shield. They were there when it was stolen. They're still alive. They recognize it and so forth. Very unusual, but a decision that Acoma made that has helped shift thinking in federal law and international law with regard to how should these items be protected. So anyway, many things happen. Heavy lobbying campaign, BIA law enforcement, the Bureau of Indian Affairs law enforcement, their funding for NAGPRA is increased by $1 million. It's gone up by $1.5 million since then to create a whole unit that just works on this. GAO, Government Accountability Office reports were ordered up because you have to create a record. UNDRIP, the United Nations Declaration on the Rights of Indigenous Peoples, has very on-point language about the rights of Indigenous peoples to control their sacred cultural items. What was the exact language you used? Just free, prior, informed consent, which we love, and then your term for cultural property, cultural heritage property. All of this leads eventually to the introduction of the STOP Act, an actual bill with teeth, even though I think teeth are necessary, but I think more objects will come back because of a change of mindset. It was introduced in June 2017, passed December 2022, actually signed into law on the winter solstice. It was a shield for winter ceremonies. I don't know if that was some cosmic coincidence, but it was interesting nonetheless. The regulations just came out in the last couple of weeks, so we're still assessing the implementing regulations. But again, it was a bill that moved on a completely nonpartisan basis. At one point, a US Senator out of Utah, Senator Lee, very conservative senator, put a hold on the bill. He puts a hold on a lot of native bills. In Washington parlance, a hold is a senator objecting to any further movement, and any senator can put a hold on any bill and stop it cold, and theoretically forever. Of course, if you get too carried away with that, other senators put holds on your bills, and eventually a negotiation takes place. In this case, Senator Lee had put a hold on the STOP Act. It's a big impediment. Due to a long tail that I cannot tell you now because Eden now thinks I have 1 minute left. The Trump White House came out in favor of the STOP Act, and Senator Lee pulled that hold the very day he was informed of that. And why? Long story, happy to talk about it afterwards, because of a human-to-human connection that occurred at the White House that got White House officials realizing that this was something that was not political, but was very important, really, to the identity of the United States itself. So, I've written about some of this in your materials. The STOP Act itself does things like increasing NAGPRA penalties from 5 years to 10 years. You say, well, why that little detail? Just so you know, it was because we were told that if the maximum penalty for a crime is 5 years, federal prosecutors don't bother to prosecute. But if you increase it to 10 years, they're much more interested. So little subtle things like that. And again, I'm not for black helicopters swooping in per se, but the law is filled with things like that. It also has a big emphasis on voluntary return. And as I described at the beginning, the Pueblo of Acoma is having an unbelievable amount of incredibly sensitive stuff returned. And that is powerful, and it's uplifting to their community, and it's allowing the full restoration of certain ceremonies. And it also just means we're being heard. We're being valued finally, and it's going to be a process. It's certainly not everything is magically resolved, but the idea that the tribes should be the ones who determine the value and meaning of things and make the decisions about where they properly belong when it is these sensitive cultural items is taking root. And the dealers and some of the collectors, some of the museums are very afraid for their collections, this or that, sometimes because they know that they hold very sensitive items, and maybe they're in it for commercial reasons, maybe for other reasons. But the world is changing. I've encouraged them in presentations to the dealers to actually stop retreating and go out and talk to the tribes you're dealing with and get to know them as communities. You might be surprised that the relationships you develop, and maybe you return some things and then they share some things with you, because there is no more giving people, in my view, than Native people who are so deeply relationship based. So that's kind of the non-law law of how that STOP Act got passed, and it's already significant impact as a statement of value, of US values, with more to come. Thank you.
Thank you, Greg. And I will, oh, yes. I will one-up you on the pop culture, and I will say that the line from Indiana Jones, and I think it's in the Holy Grail that I always think of, is when his little British sidekick says, "Don't worry, Indy, the museum will take whatever you have, no questions asked." So that's always the part. My family won't watch that movie with me anymore because that makes me want to scream. So, so thank you, Greg, for that. So I have a couple of questions, and I'm happy to take any audience questions as well. Shannon, you talked about the importance of NAGPRA, but what about other options? You know, Greg was talking about dealers and maybe museums talking directly to tribes. Is there a more positive way that these can be addressed, maybe even more efficient because of the challenges and time delays and expenses of NAGPRA? What are the other options?
Right. We spend a lot of time talking about the failings or what's not happening under the law or laws. But what has happened is when NAGPRA began 34 years ago, there have been about 218,000 Native ancestors that have been noticed under that law from domestic institutions. It could be more. There's likely many more that have not been noticed, but publicly we know that there's been 218,000 noticed. More than half of those ancestors have been repatriated. So there is good work that's happening. And those institutions who in the first 30 years did what NAGPRA asked them to do, built relationships with those Native nations that many people in the museum and in other institutions didn't expect. They learned that the tribes were the primary experts of their cultural heritage. And they learned that they didn't know what was actually in their collections. And so through that, relationships built where tribes and museums were able to partner to actually better educate the public about Native cultural heritage, right? So a lot can happen, a lot of trade in ideas and relationship building so that you can fulfill your mission as an institution. But there's other opportunities too. I know Greg mentioned charitable contributions. Tribes are just like a 501c3. You can donate those items that you shouldn't be selling and marketing to those Native nations, and quite often that return, that recognition is met with care and love and a long time relationship. We've really seen minds change through the process of repatriation that provides healing not just for Native nations, but also the people who have been carrying that burden of a stolen object with them. So did that answer your question?
Yes, and I'll add, and you can confirm that many tribes also have their own nonprofit code and therefore their own tribal nonprofits. And in my experience, people have been reluctant. They don't understand what a tribally organized nonprofit really is. So I think some education in the public would be helpful in encouraging those relationships as well. Melanie, can you hear me? Okay, good. So I wanted you to pull out your crystal ball and tell us what you think might happen with these new regs. You know, we already talked about the blankets covering the cases and things of that nature. And there is a 5-year deadline for compliance, which seems pretty tight for especially the larger collecting institutions. What do you think might happen in these next 5 years before that deadline?
Well, I think a lot of consultation, a lot of relationship building, and I think a lot of successful and meaningful relationships will come out of the next 5 years, now 4 years, as museums are again required to work directly with tribes to resolve the rights to these Native American ancestors and items. You know, I realize the 5 years may seem tight in the long history of the 34-year history we've had with NAGPRA, but the reality is that was the original timeline. Congress gave museums 5 years. This was all supposed to be done by 1995. And it wasn't. We know that now. And so we're trying again. We're trying again to reset the requirements and reset the expectations that it is Indian tribes and Native Hawaiian organizations who are the proper owners of these ancestors and items. What I've been saying with my crystal ball, because I have to believe this, is that in January of 2029, I'm going to be inundated with all of these incoming documents. I'm going to record them all. We're going to publish all of these notices in the Federal Register that will finish all of this work. And then I'm going to go on a 6-month vacation. But it's possible, and we've already seen huge change. I mean, we've seen over the last 2 years a significant increase in the work. And I want to just take the opportunity to add my own little pop culture reference here, maybe a slightly updated one from Indiana Jones. And that is, there's an author who's written a book called Warrior Girl Unearthed. It's by the author's name is Angeline Bowley. And she describes this novel as Lara Croft, Tomb Raider, except she's indigenous and she's stealing objects from museums. So that's the premise of this book. She dedicated the book and it's a work of fiction. She dedicated the book to the 108,000 ancestors that are still in museums when she published the book in 2023. Every time I see Angeline, I have her cross out that number and write the new number of ancestors that are still held in museums. The last time I saw it was 95,000, and now we're down to 90,000. And it's a wonderful book to really get into this topic, but I would also want to encourage anyone in the room to look at, there's one part of the book where the young woman is tasked with looking on eBay for objects of her culture that are for sale. And when she does, she then relates what she calls a true provenance of this item that she found for sale on eBay. It's a vest, a beaded vest. And it's just one of the most powerful things I've ever read to really get at what these items really are and why they're so much more valuable to these Native people and to the Native nations than they could ever be in a market or at auction. And so I'll leave you with my own pop culture reference there.
Thank you. I always love a good book recommendation. So I know we're coming up against it. Greg, I just wanted to ask you briefly, what would you say the biggest challenge is working with tribes? We talked about tribal sovereignty and a limited understanding. I know there's frequently a shortage of resources. And as Shannon mentioned, with everything that they're managing, healthcare and education and basically a country's worth of responsibilities, is there one or two things that you find particularly difficult or challenging for the tribes to deal with?
Usually resources is the obvious thing, but something I hinted at the beginning is I talked a lot about the process of getting dealers and the rest of the world to perceive these things in a certain way. I believe, I'm not a tribal citizen, so Shannon can speak to this better than I, but the tribes have to go through their own process as well as to how to interact with the outside world. That's what Acoma did. Many other pueblos came up to the Acoma governor and thanked them for doing that because they wouldn't have been able to do it themselves based on what they believed was appropriate. But they were thankful that for Acoma making a decision for itself, it benefited all of them. So there's a lot of, it's all at the end of the day inside our minds and inside our spirits. And that's true for all parties in these matters.
Great, thank you. I think we have maybe a minute left. If we have one question, we could take one. Yes, please.
So her client or someone has a pipe bag. Yes, that's a sacred object. And she has a bill of sale, right? And is it appraisable? Well, that's my question back to you all, considering how you're regulated as an industry, that you're not supposed to discriminate, that you're supposed to have competency. And so what I was hoping was understood from my presentation was that, you know, the primary experts are Native nations. They're not the dealer, they're not a private collector. And for you to truly understand what an item is, you've got to go to the affiliated Native nation and ask them. It could be a legitimate gift that they're aware of, but it's quite likely, you know, the experts at Native nations, I'm always just like blown away by their level of expertise. They can tell by this, they know everything. But the concern there from Native nations is once they start having a discussion about what that item means and what it is and whether it's properly held outside of their nation, is they're very sensitive about not sharing all information, because that information you will take and then value the item higher.
I have some thoughts, but I'd be interested, yeah, to wrap up. When somebody does make a donation like that, the tribes will provide, the ones I know anyway, paperwork saying you've made the donation, but they won't place a value on it. They don't care. Usually the person who gave it will place a value and report to the IRS that they gave a $10,000 item to a certain tribe, and the tribe, yeah. 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 It's, how do you value something that's priceless? So.
Yeah, thank you for the
We
question.
can
That's a very
talk more.
interesting topic. So thank you, everyone. That's our time.
Thank you, Eden. I want to thank you all for coming. Steve, Diana, thank you so much for all of your help planning this, and to the entire Art Law Committee. I hope you'll gather your things and join us at the Salmagundi Club for a drink. I think we need it this week. Thank you all for attending and coming.